May I have your lordship to mention the matter for extension of interim order. But the interim order expires on 31st of this month. But matter is at serial number 794 of the monthly list.
But may I have your lordship? But under the comparing circumstances, my lord, I am mentioning for upgradation 977. The lady is 80 years old, and for the last 10 years, I am coming before your.
Is it a hearing matter?
No, my lord, motion.
Motion. Give the number.
My lord.
Well, may I be permitted to mention, well, I am for the respondent National Health Authority, but it has been listed 483, but it has been stayed, my lord. But report has been filed, the exception has been filed. All are complete. If it is upgraded, my lord, otherwise work has not been completed, my lord.
Give the number.
My lord, may I be permitted to mention serial number 141 of today's list, my lord.
Please do not.
My lord,
mention.
Lordship,
may I be permitted?
On 27th August.
Comment, please.
Lordship.
My lord, kindly, my lord.
Content matter, please give the number.
My lord,
Content matter, I mean. Yes, where is it recorded that it will be demolished?
Fourth paragraph, my lord.
Yes.
In fourth paragraph, my lord. The subdivision also directed me to demolish this structure within 27th August. Otherwise,
Come back.
my lord.
Without any
May I-
without any conversion of land, my lord, the pond is being filled up. This is very urgent. Item number 348. A pond, there was a big pond.
Inland Fisheries Act. Inland Fisheries.
No, my lord, this is
If it is conversion, then this court will not.
no,
have
no,
jurisdiction.
no conversion has taken.
So this court will not have jurisdiction. It's
My
under
lord,
the Land Reforms Act.
without conversion, my lord, they are filling the pond, my lord, land.
The number, please.
my lord, may I be permitted to mention? My lord, 849 of the monthly list.
Yes.
Lordship, the urgency is that the PWD has issued a notice to SDPO for demolition, execution of the demolition order, and it has been issued on 28th of July. So it can take place anytime. We have challenged the demolition order of the SDO Diamond Harbor on grounds of lack of natural.
The
resources.
number.
May I permitted to mention, lordship,
Matter was fixed, my lord, on 1st August at 12:30, my lord. Matter appeared on 7th, my lord, at 12:30. Lord, logically recollect, this is the matter I have completed my signature. Mr. Talukdar will, my lord. Can you fix the other date at 12:30?
Lordship, may I permitted to mention? Lordship, may I permitted to mention? Lordship, petitioner land had been acquired in 2010 and no compensation has been provided to till the date.
Matters.
Lordship,
How many matters?
one matter, lordship.
Give the number.
My lord, may I permit
May I permit to mention one matter, my lord?
Affidavit has been exchanged, lordship.
Matter, my lord.
Should not mention supplementary list matters because they will not be upgraded. That's the ground on it which I take. the mention.
I am waiting for 5 months in the combined list. Don't kindly upgradation.
Give the number.
My lord, may I permit to mention? Restoration.
Matters, my lord, land acquired, my lord, without compensation, my lord, being utilized.
Give the number.
My lord, under compelling circumstances.
Application for appropriate order, my lord, private, my lord, enjoying the interim order, my lord. Recently, the government, my lord, fund is not, my lord.
Give the number.
My lord,
Lordship, affidavit had been exchanged.
Item number.
correction
of the order. Correction of order, give the number.
my lord, correction and restoration.
The number.
My lord, correction and restoration of matter.
The number.
দাঁড়াচ্ছেও না, এ তো বসেই রয়েছে।
Please wait.
Land acquisition matter, madam. Your lordship has already almost heard the matter. The farm is also there, one of the parties. And my lord, wherein, my lord, the Nepal government, my lord, what is that matter. My lord.
It's a hearing matter.
Almost matter is.
The number. It's a.
Item number, my lord. Of monthly.
Give the number.
Directed me to mention this matter for fixing a date of hearing, my
Give
lord.
the number also.
My lord, may I be permitted to mention?
Yes, I told you to give the number. Yes.
My lord, may I be permitted? listed motion item number 705 to 12. 8 listed motion are same and identical. Only 28 the application is pending before the land acquisition collector from 2014 for disposal and for consideration and disposal my application. Listed motion.
Two identical matter, my lord.
My-
Lands of the petitioner are acquired for construction of national highway, my lord.
Madam,
But in this, my lord, they have-
আরে কি করছেন আপনি কি করছেন কি এটা
Not
এরকম
allowed.
চেঁচাচ্ছেন কেন?
নিচ্ছে না। বল।
Praying for compensation only, my lord.
Listed motion, my.
Same matter, একসাথে রাখুন।
Same and identical, my lord. Eight
একবারে
matter.
dispose of problem. Same matter, একসাথে
Same
রাখুন,
matter, my
একবারে
lord.
dispose
My
of
lord,
Under compelling circumstances, my lord, I mention,
correction and restoration.
my lord, under compelling circumstances, I mention, my lord, one matter. My lord, I want to leave, my lord, 18th, the notice was issued for demolition.
Yes.
My lord, my application under 8(2) of the Highways Act is pending. Without disposing, they are issuing the notice and
What is the
25th is the
Demolition
demolition. 25th, my lord.
File and come back, give the number.
Yes, my lord. My lord, otherwise, my lord, government pleader office not take the brief, that's why.
Please file and give the number.
My
My lord.
Stars with you.
My lord,
My
two
lord,
identical
wait,
matter, my
need to mention.
my lord, unless, my lord, leave granted, they not receive.
48 hours with you. So
My lord-
please file and come back in the ordinary.
My lord, 25th is the demolition. My lord, tomorrow, my lord, I want to, my lord, otherwise, 23rd, my lord,
No, leave will not be granted.
25th is the demolition order, my lord.
Not-
My lord,
two identical matter appearing in the monthly list, my lord. My lord, they got the.
You have just mentioned few matters, isn't it?
My lord.
You have just mentioned other
No,
matters.
no, my lord. I have mentioned your lordship, my lord, please to accept the matter, but slip has
Yes.
not been accepted, my lord. They are praying for only compensation, my lord.
Give the number.
my lord, correction and restoration.
My lord,
My lord, I beg to mention, my lord.
My lord, correction and restoration.
Correction, restoration, give the numbers.
My lord, I beg. Ma'am, my lord, read petition of 2007,
Tomorrow.
read petition of 2017, my lord, not being heard.
My lord, may I have your lordship's kind?
My lord, the petitioners
land-
are very poor, my lord. They are not being able to.
What will the difference be if it's heard to, if it's taken up tomorrow instead of today? Madam,
My lord, at least I,
become poorer? Please make sensible submissions, sir. Please come back tomorrow for the
ma'am,
remaining
my lord,
mentionings.
2017 read petition, my lord, not
Once
being
has
heard.
been taken, sir. Please come back tomorrow. Tomorrow.
My lord,
Tomorrow. Was not there. Give them.
my lord, land
May I
acquisition
continue to
proceedings.
mention your lordship? The
I have
exam,
just
the
said
private.
I-
Lordship, this is for
Please come back
non-prosecution.
For the remaining mentionings.
Lordship
please
for
come back
non-prosecution, madam.
tomorrow. I think I have to restrict mentionings to 10 matters a day. It will not be possible.
Lordship, may I take your lordship's leave for non-prosecution?
Tomorrow, non-prosecution, give the
Non-prosecution.
number.
My lord, I pray for a leave, my lord,
Okay.
exigency is that, my lord, the eviction suit against me has decided in my favor. This honorable court have passed the order in favor of me. And after that, honorable chief justice court has set out a guideline. And that has been violated and a contempt petition is pending. In spite of that, my lord, the respondent authorities are sending me the eviction notice, my lord. Kindly take it any day, at any
File
point.
and give the number, I'll fix. I'll take it, take it up.
I'm getting,
Leave will not be
I'm
granted.
getting.
Should I come back tomorrow, my lord?
Please, please. It's difficult, 100 and odd matters every day for
It's
mentioning.
better, my lord. I have, my lord, the third day, my lord, I could not even, my lord, talk to your lordship because of, my lord, the rush.
Bad luck, please come.
I'll come.
Well, same thing, well,
Yes.
since last 2 days, well, I'm trying to mention for
Let's come back tomorrow. And
Item
remind
one.
me that you're waiting for 2 days. I'll take
But
it up.
well, one matter, my lord, I have already filed. Well, the 25th is the date given in the presentation form, my lord. The urgency is this, my lord. During the pendency of this writ petition, my lord, the authority concerned already issued a tender notice for issuance fresh lease deed to the other party, my lord.
Mention tomorrow, I'll consider.
My lord.
Since I have refused the other mentionings, yes.
Item one.
Correction of-
But I do not know why this has come.
There's a correction in the year. Acha. বাইশ হয়ে আছে না এটা সবই সিপিএন না ডাব্লিউ কি এটা 1289 of 22 21 হবে inadvertent error has crept into the order orders passed on July 20, 2023 and July 13, 2023. Paragraph in the said orders, WPA 12839 of 2022 be read as WPA 12839 of 2021. Paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the orders passed on. I do to now, order given. Urgent certified.
Item 2,
But I'm for the petitioners
Yes,
and serve the copy
correction.
also earlier. And there's a evidence.
Why to be mentioned?
The fact remains here that the petitioners are the brother and sister by relation. And they are the owner of a property, and by virtue of a sanction plan from the concerned municipality, they have just erected a two-story building. And the brother and sister are residing there, both the brothers and sister. And after just residing there, after getting in sanction plan from the municipal authority, they have paid the taxes, municipality taxes and nutrition, everything is there. And since long, and thereafter, the land department has informed us that the nature of land is pond. So there is a question. So we informed the matter to the municipal authority after getting a sanction plan from the municipal authority, after submitting all these things, and tax is paying there, and nutrition certificate also there, and we are giving just the tax to the government authority concerned, PL and LRO
You're
also.
asking for conversion.
Yes, now kindly may I permit one thing. So relating to that matter, just Lordship knows very well, so far the 4C of the Land Reforms Act is concerned, that the ADMLR is the authority concerned to convert from one to another. That is Shali or pond to Vasco. So we made an application to the ADMLR authority with a prayer for conversion of the land from this to that, from pond to Vasco. And very unfortunate that it is the dictum of law under section 4C of 2 that within 1 month that matter should be, that representative should be disposed of.
This court doesn't have jurisdiction to.
I am
take
coming
your
to that.
case.
I am coming to that. So after 1 month, the representative is pending there without giving any information, without hearing of the
Maybe.
matter.
Maybe.
Now this court, because the reed court has got the jurisdiction in this sense, that any executives or the selective board, any board authority concerned relating to the land matter, so refused to discharge his duties, which was vested upon him. In that event, the reed court has got the right to interfere with the matter under section 2, under article 226 of the Constitution of India, especially relating to the land in question and article 300A. So for the land in question is there.
All that
So
no quarrel, all no dispute, but this is a specified act. This, sir,
No, no.
please do not spend further time on
No, I'm
this.
coming to that because there is observation of our High Court as well as the Supreme Court is
That
concerned.
even in a specified act, the court can deal with this matter?
Yes,
Please show me the observation.
there is an observation of. Just the Constitution of India, Article 226, start form. And it is Justice Shomen division bench comprising of.
That's not the Supreme Court, sir.
No, this is our High Court, Calcutta High Court. This is our High Court.
Yes, please show me that even in a specified act, the court can pass orders.
I'm coming to that. Scope and proper Article 226 of the Constitution of India, a discretionary and supervising in nature, not to be used merely as it is lawful to use, not to set right mere error of law, which do not cause substantial injustice. Party claiming equity must come with clean hands. Power under Article 226 of the Constitution can be exercised by the statutory authority, because ADMLR
Can be, it is the discretion of the court.
Well, kindly allow
Unnecessarily,
me.
you are spending time, sir.
No, I'm coming to that. And the authority not acted in accordance with law, violation of the fundamental rights, natural justice, and alternative remedy, a factor to exercise the power of Article 226 of the Constitution. So we are concerned with the executive officer. ADM LR is the executive officer, and the vested power vested upon he is also a body concerned with the land in question. So he refused to, and the 4C of the Land Reforms Act of Clause 2 has vested upon the concerned authority, executive authority. He discharged his duty. He did not discharge his duty. In that event, the writ court has got the power. But the only thing, kindly see, I'm coming to 4C. I'm coming to 4C. Only thing that the representation has not been considered. The Lordship has given a direction to the concerned authority to consider my representation, nothing else. Kindly come to 4C. A riot holding any land may apply to the collector for charge of area or character of such land, or for conversion of the same for any purpose other than the purpose for which it was settled or was being previously used, or for alteration in the mode of use of such. Number 2, it is my case. On receipt of such application, the collector may, after making such inquiry as may be prescribed, and after giving the applicant or the persons interested in such land or affected in any way an opportunity of being heard by order in writing, either reject the application or direct such change, conversion, or alteration as the case may be, on such terms and conditions as described. So my hesitation is this, that the one representation was given to the concerned authority, ADM LR, and that representation has not been considered within a month as prescribed in law, and that should be heard out.
That's
So,
all your submission.
Yes. So only direction may kindly be given. So
I'm
this is my-
sorry, sir, your case has to be dismissed. I can give you an opportunity to withdraw.
Sir,
It will be dismissed by reasoned order. Not maintainable before this court. It's under the specified act. The act very clearly says that you have
Yes.
to go before the tribunal.
So
In connection with anything connected to the specified act.
no, kindly hear me one thing.
You have completed your
Yes.
submission, sir.
Kindly hear me one thing. So the alternative remedy is also there.
No question of alternative remedy. The statute is a bar. There is no question of alternative remedy. The statute itself is a bar.
So once again, I'm coming to another decision of the court. I'm coming to that.
Sir, I'm afraid it will not help you. You can continue, sir, if you want to. I'm sorry, it will not help you.
My lord,
Because
may I-
the decisions cannot override statutes.
no, but the fundamental right of a person, even the relating to the land in question.
You'll have it before the
Article 300
authority.
No, Article 300A of the Constitution of India, this writ court has got the right to interfere with the matter and to entertain my application. So,
Please come to section 6 of the West Bengal Land Reforms and Tenancy Tribunal Act. Section 6 and section 8. That makes it clear.
Land Reforms Act.
Tenancy
Tenancy.
Tribunal Act.
My lord, there is a provision in 72 of the Tenancy Reform Act. Even there is a ample jurisdiction.
Land Reforms and Tenancy
No, no.
Tribunal Act.
Yes, 72. There is a specific provision, but the books is not with me right now. The books is not with me. But in this context, may I submit one thing?
Yes.
May I submit one thing? To came into conclusion about the matter, whether the writ court has got the right or not.
There is no section 72 in the act. There are 25 sections in all.
Tenancy Act 70.
I'm not talking about Tenancy Act at all. I'm talking about the West Bengal Land Reforms and Tenancy Tribunal Act, 1997.
No, that book is not with me.
Sixটা পুরো 6 and 8. 6 হচ্ছে jurisdiction, 8 হচ্ছে bar of
But this is the statute. This is the statute. Now so for the writ judicial is concerned, So the read jurisdiction has got the wide power of the read court. So I
Not
am-
beyond the statute.
My lord, appreciate one thing. So read jurisdiction has got the wide power of the read court. So in that event, any discretion power of any executive officer or the sanctioned body of any competent authority is not discharged its duties. In that event, the read court has got the jurisdiction to that interfere.
Yes, of course, writ court by the division bench. Please come to section 8. Please come to section 8.
My lord, I have gone through the section 6 and 8 earlier. I have gone.
I'm sorry, sir, I cannot give
Regarding-
you further time.
Well, in that event, may I submit one thing in that event? So I will satisfy your lordship because I don't have the Supreme Court's order right now, observation. So I may kindly be allowed only for a week, only for a week. I will satisfy over the matter because the specific provision is there, a specific provision which is override the writ court observation in the Supreme Court. If I not satisfied, then it will be up to the law.
Very well.
So only 1 week may kindly be allowed because in so many cases the Supreme Court has exercised the power.
Not in a specified act, sir. I have gone through all the judgments of the Supreme Court, most of them, not in a specified act. You can come back. If you want to, you can come back. In a specified act, even the Supreme Court doesn't say so.
My lord, in different situations.
They are all
like
general,
this,
general
like this
orders with regard to Article 226.
My lord, in different situations, so far the Article 300A is concerned, related to the land matter. In that event, I think so that, yes, I will satisfy your lordship. Kindly allow me.
I wanted to pass a reasoned order, sir.
No, I will go for the Article 300A of the Constitution of India. And in
You have
this context,
submitted that.
in this context, my lord, the observation of the Supreme Court is not with me right now.
Very well, come back, come back.
So 1 week may kindly be allowed to that. If not satisfied, then the court will decide over the matter.
Heard learned counsel for the petitioner. Paragraph. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the heading motion. On 8th September. 8th September.
So the notice has already been served upon the opposite party.
Yes, yes,
Thereafter.
sir.
Yes, exactly.
Next.
8 September.
Item 3.
Item 3, I am for the petitioner. Matlab, out of court matter is settled. Matlab, I want to
Oh, you want to non-prosecution?
non-prosecution.
Learned counsel for the petitioner submits that the petitioner does not intend to proceed with the matter any further. Petitioners, since the dispute between the parties has been amicably settled. Paragraph, in view of the above, the writ petition being WPA such and such is dismissed for non-prosecution. Paragraph, there shall however be no order as to costs, urgency referred website. Why? No? That will be a fresh cause of action in any case.
Item 4.
Item 4, my lord. I am appearing on behalf of the petitioner. The restoration application under I have stated in
Yes,
paragraph-
restoration.
Yes, ma'am.
Have you
Paragraph
served?
two.
Have you served?
Earlier, advocate in the state panel is no longer in this manner. That is why I sought the government pleader.
And who is appearing?
Earlier, Suprabhat Bhattacharya. But he is no longer in the panel manner. That is why I sought the government pleader.
This is a second dismissal, sir.
Yes, my lord, it is my fault, my lord. Can you see I have stated in paragraph 2, my lord.
So next time you will not be that lucky.
I am ready.
None appears for the respondents despite service of notice. Can 2 of 2023. Paragraph, this is an application for restoration of the
I have stated in paragraph.
writ petition which was dismissed by an order passed on 16 June 2023. The writ petition was dismissed earlier by an order passed on 7th February 2023 and restored to its filer number by an order dated 31st March 2023. This is a second occasion of dismissal of the writ petition for default on the part of the petitioner. Paragraph, however, the application for restoration of the writ petition is allowed in the interest of justice. Paragraph, the order passed on 16 June 2023 is set aside. Paragraph, the writ petition be restored to its original file and number. Paragraph, there shall however be no arrest to costs. Urgent certified website. Oh, can such and such is disposed of. এটা হবে না, cost টা হবে না। Can such and such is disposed of? Urgent certified website copy WPA তে order করুন। Let the matter appear under the heading Group 1 motion on 18th September. Next dismissal will not help you, sir.
Item 5,
Five order disposition application. I am not good on record working on it. Because
Have you served the other side?
my other side, nobody is appearing.
Yes.
First time we appear and dismissed by my lord. My lord it is dismissed on 4th of July 2023. And I filed application on 1st of August 2023. And my lord, one thing, my lord, I'm playing one thing. My lord, it's a completely defective application. Allow me to kindly restore and allow me to withdraw to fresh.
You'll file a fresh application. Can 1 of 2022. This is an application for restoration of the writ petition which was dismissed for default by an order passed on 4th July 2023. Paragraph, sufficient grounds being made out. The application is allowed. Paragraph, the order passed on 4th July 2023 is set aside. Paragraph, the writ petition is restored to its original file and number. Paragraph, can such and such is disposed of. Paragraph, WPA te order korun. Learned counsel for the petitioner seeks to withdraw the writ petition on the ground of certain defects detected therein and seeks further liberty to file a fresh writ petition on the same cause of action. A fresh writ petition on the same cause of action. Paragraph, in view of the above, the writ petition being WPA such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to file a fresh writ petition on the same cause of action. Paragraph, there shall however be no arrest to costs. Urgent certified website.
item 6,
Served and yesterday night, I have what telephone I have informed my lord, Mr. Construction last night.
Restoration. Order passed on 21st November 2022. শুরুতে করবে none appears for the respondents despite service of notice. This is an application for restoration. Date হচ্ছে 21st. WPA তে order করুন. Let the matter appear under the heading Group 1 motion on 18th September 2023. Please inform the others. Paragraph, the petitioner is directed to serve notice upon the respondents intimating the adjourned date. না কিছু বলেনি, নোটিশও দেয়নি, দরকার নেই কিছু বলার।
item 7,
Yes.
Restoration application.
There,
Yes, my lord.
let it be restored.
Yes, my lord.
Can we take up the writ petition
Yes,
today?
my lord. Dispose of this matter, my lord. We wanted to a certificate of exempted category, my lord. That is he filed an application before the ATM. My lord, that application will be considered by the ATM within certain period. As
Yes, let it be considered.
Subsequently, after filing the writ application, my lord, they have checked.
Please switch on the microphone.
Yes. Well, subsequently, my lord, after filing of the writ petition, in the year 2021, she was called for, my lord. The one land was taken of the by the land loser as a land loser. Land loser certificate has been issued, my lord. And on the basis of land loser certificate, there is a provision that the she will be treated as an exemption category. On the basis of that, he was applied for the primary school education, my lord. And thereafter, as an exemption category, but he prayed again and again to give this exemption category certificate, but they have not issued. And after filing the writ application, my lord, they have issued a letter, my lord, that they are telling that the land has been acquired for the project of central government railway project. But the land has been acquired by the West Bengal government, but they have stated on the plea they have rejected, and they
So that is a separate cause of action.
separate subsequently.
It cannot be dealt with in this writ petition.
Yes, madam.
So let the writ petition be disposed of.
Yes, madam.
That is a separate cause of action. You have to come.
Yes,
to the
yeah.
petition, isn't it?
Yes, my lord.
Yes, Mr. Dev. Let this be disposed of.
Yes, ma'am.
Can 1 of 2023, restoration and order. Mr. Dev. 24th April 2023 order to set aside have rest order. WPA pe order korun. By consent of the parties, the writ petition is taken up as a treated as on days list. Writ petition is treated as on days list and taken up for consideration by consent of the parties. Paragraph. The writ petitioner sought a direction upon the respondents, particularly the additional district magistrate within bracket LR, Bankura, to issue certificate
Exempted category.
in her favor under exempted category as a land loser. The petitioner submitted a representation in this regard before the concerned authority, which not being considered, she prayed for a direction upon the authority to consider the representation at the earliest. Stop. Paragraph, it is submitted on behalf of the petitioner that during pendency of the writ petition, the representation submitted by the petitioner has been considered and rejected by the authority. Paragraph, in view of the above, nothing further remains to be adjudicated in the writ petition, and the same is accordingly disposed of. Urgent certified website.
Please file.
Liberty is not required because that is a fresh cause of action.
Yes.
Not the same cause of
Yes.
action. Next.
Item 8.
8 and 9, my lord. But you're also given liberty.
Oh, yes.
Monday also we search in the department. Last Monday we could not get the trace out the file.
Then not today, not this week.
No. Not it is not possible because I have to file a review application along with that.
Yes, but the file has not come from the department.
What is?
I'll make it not this week.
2 weeks time is required, my lord. 2 weeks time, and you'll also give liberty to file a review application.
I cannot pass an order today because
That is the
file
reason.
is
Yes,
not
yes,
there.
yes.
So let me just make it not this week.
Not
Let the file come in the meantime.
yes. I'm good.
8
Same.
and 9.
8, 9, same. Same.
Item 10.
Lordship, I am led by Mr. Panchanan Hazra, behalf of petitioner.
Yes.
Lordship, this is first time.
Appearing for the first time. So please serve notice and come back. The applicant is right to serve. Is right to serve a copy of the contempt application along with annexure thereto upon the alleged contemner and submit affidavit of file affidavit of service on the urgent date. Paragraph, let the matter appear under the same heading on 20th September.
Item 11.
11, I am for the petitioner, Mr. Santanu Moitro, for the state. Yesterday, again, I served him a writ petition. Your lordship, can you see your lordship on the last occasion, direct me to produce the original certified copy of the order of withdrawn of the suit. Your lordship, order is there. এইটা দিন, এইটা জজ সাহেবকে দেখিয়ে দেন, এই দিন। Left hand side, your lordship can see case number, column number of suit 183.
You are the plaintiff.
I am the plaintiff. I withdraw. And there is an order in the said certified copy. There is an order. But order is not that the original plaintiff is returned to the plaintiff to present it before the proper forum. Not I have not filed any suit. Now, facts is not total 30 decimals of land. Out of that, 7 decimals government acquired and give me the compensation. But rest not 6 decimals. I have 2 decimals, but not 4 decimals they again take up. But no notice was served, nothing was there. Now, my lordship, kindly see page 18. Not page 18, your lordship, kindly see. Page 29.
Page?
29.
Yes.
Your lordship, kindly see the additional distinguished state. What is state? As the matter is related to with the land compensation, he is advised to contact with the LA office, but want to get relief as paid for. Not since then, again, your lordship, kindly see page 32.
You approach the LA office?
Yes, ma'am.
You approach the LA collector?
Yes, I approach. Your lordship, kindly see page 32.
Yes.
It is against my letter, my lord. The district magistrate says this. But did not sat tight over the matter. Then again, Lord, I made a representation again. Your lordship, can you see page 33? This is my last representation. Either, Lord, they return my land or they give me the compensation. This is my prayer.
With the 7 decimals, you have no dispute.
No,
Dispute is with regard to the
only 4 decimals. Only 4 decimals.
So let your representation be considered within a stipulated
Yes.
time frame.
Yes.
And please serve a copy of the order as well as the representation because
Yes,
the
yes, I
statement
will,
of
I will, I will, Lord. I will.
miss the bus.
Oh, I তোমার কথা
Just I am
বলেছি।
rushing.
তোমার কথা বলেছি আর।
14 minutes.
He has filed a representation before the authority. Let that be
But your
considered.
lordship kindly sees, my lord,
You have taken away 4 decimals extra.
my lord, it is his allegation, my lord.
Yes.
It is his allegation, my lord, and on the last occasion, your lordship pleasure was that your lordship was to see. my lord,
Yes,
the
I
certified
placed.
copy of-
That is
I placed, I
written,
placed.
yes.
My lord, land was acquired in the year 1970, prior to 1975, and first representation has been made in 2011. Thereafter, he kept mum,
No,
and my lord, he woke from his deep slumber.
I regularly
And
went there.
2022, he made a lawyer's notice, my lord.
And since 2012, you have kept mum, sir.
Lord-
Please come to page 32.
Lordship, my lord.
What steps has the state taken after that?
Let me, my lord, take instruction whether, my lord, what steps
we have taken and the action taken report has been furnished before the land acquisition officer. Your lordship kindly,
2012, we are in 2023.
lordship, and that's why my lord, I am taking the point of maintenance of this on the ground of delay, my lord. 1975. Yes, after 2012, they kept.
How do you explain your delay first? Before the petitioner's delay?
I do not know whether the action.
The petitioner has filed a fresh representation. Let that be considered by your authority within 1 month.
Lordship.
Since 2012, the authority is sitting tight over
I
the
do not
matter.
know whether that action taken report was served upon him or not.
No,
Whether he
No,
submitted or not.
nothing. They sat
I
over,
do not know.
sat right about the
you are
matter.
not ready with your documents and you are alleging suppression. You should have your own documents.
Well, that's why I am praying, that I should take instructions, but 7 days time may be granted.
On the earlier date also the same.
Yes, yes,
You
yes.
have not taken
4
instructions.
times the matter
No.
came before your lordship.
You have taken several dates for instructions. On the last date also, it was adjourned on your prayer.
Lordship, because on that day.
So without wasting further time, let the representation be considered.
Yes.
You can take this one.
Hey, Jamidi.
It is submitted on behalf of the petitioner that the title suit filed before the learned civil judge junior division, second court bird 1 has been withdrawn by the petitioner. Stop. Paragraph. It is contended on behalf of the petitioner that
It's only the.
out of 13 decimals of land owned by the predecessor, owned by the petitioner in plot number 615, Khotian number 1515 of Moja Amdob, AMDOB, jail number 40, district bird 1, originally belonging to his father, 7 decimals were acquired by the state. By due process of law. Stop. It was subsequently found that out of the remaining 7 decimals of land in the plot, 4 decimals were utilized by the respondents without acquisition. Stop. The petitioner made several representations before the concerned authority seeking return of the said 4 decimals of land encroached upon by the authority,
May I?
but to no effect.
That out of lot 7 decimals has been acquired, I get the compensation.
Allegedly.
Out of 6 decimals,
Yes.
4 decimals, they without giving any notice.
6 crore. Out of the remaining
yes,
6 decimals of land,
Allegedly
4
encroached.
decimals were utilized.
yes,
Allegedly,
yes,
Yes,
allegedly encroached.
submission of the.
yes.
The petitioner submitted a fresh representation before the concerned authority on 5th July 2022, which is also not considered till date. Stop. The petitioner seeks a direction upon the authority to consider the representation at the earliest. Paragraph. Denying and disputing the contention of the petitioner made in the writ petition, comma, learned counsel for the state respondents submits that who should consider? Land acquisition collector.
Collector, I think so.
That the second respondent be directed to consider the representation submitted by the petitioner in accordance with law. Paragraph. In view of the above, the writ petition is disposed of, directing the second respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, comma, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof.
But your lordship has not gone into the merits of the matter.
I have not gone, not necessary to state. I have only recorded this.
Yes, only the
And the
dispose
contention
of the
I have not seen the observation at all.
Lordship.
grateful to you.
Next.
Item 12,
My lord, I beg to appear on behalf of the petition in this matter, my lord.
Yes.
My lord, my writ petition is on a very narrow compass. My lord, 3 dark numbers, land under 3 dark numbers for acquisition by the highway authority. My lord, so for National Highways Authority, so for 2 dark numbers, I have received the compensation. So for 1 dark number, my lord, kindly come to page 16. Award was issued, page 16.
You serve the state.
Yes, state as well as.
Highway Authority,
State is also a
Yes,
party.
yes, yes.
state has also been served.
Yes, well, because they are the disbursing authority.
Yes.
So if your lordship kindly takes page 16 for one.
Mr. Day, may I request you? State is served. Please serve a copy to.
Yes, yes, absolutely. আচ্ছা, আমার থেকে করে দিন।
If your lordship,
Page 16, kindly for once. Page 16.
Yes.
But kindly see, rupees 17 lakhs 87 has been allowed. এত দ্বারা আপনাকে জানানো যাইতেছে যে উপরলিখিত বিষয়ে আপনাকে স্বার্থযুক্ত ব্যক্তি বলিয়া গণ্য করা হইয়াছে। তাতে আমি 1956 সালে জাতীয় সড়ক আইনে 3(6) ধারার উপধারা 1 বা 2 বা 5 মোতাবেক এখন এককালীন 17,87,000 টাকা ক্ষতিপূরণ দেওয়ার ব্যবস্থা করিয়েছি। আপনার অংশ অনুযায়ী আপনি উক্ত অর্থ রাশি পাইবার অধিকারী হইয়াছেন। আপনার ক্ষতিপূরণের অর্থ রাশি আপনার ব্যাংক অ্যাকাউন্টে জমা করা হইবে, অতএব আপনি আপনার ব্যাংক বইয়ের প্রথম পৃষ্ঠা জেরক্স কপি এন্ড such and such. My lord, we have not received this amount, so I made the representations. My lord, we have not received this amount. So far, the other 2 dark numbers 536 and 537, we have received the compensation. Only this is left.
Where is your representation?
My lord, representation page 18.
It is submitted on behalf of the respondents that the
Well, may I take your lordship's kind leave?
the special acquisition officer should be
Respondent number
My lord, respondent number 5, my lord.
five, respondent number five.
five. Right.
I'm grateful to you.
The fifth respondent be directed to deal with the representation in accordance with law. Paragraph in view of the above, the petition is disposed of, directing the fifth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 6 weeks, from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, in the event the petitioner is found entitled to compensation, such compensation be disbursed in favor of the petitioner within 1 month, thereafter. Disposed of it. Yes, next.
13,
Lord 13, my lord, I am for the petitioner. Lord, on last occasion, my lord, I have received an affidavit filed by the, my lord, state respondent, and I have also, my lord, ready my exception.
You are filing it today?
My lord, I am filing it today.
Mr. Parthapratim Roy and Mr. Guchait, they are not in the panel. In that case, you have to serve afresh to the GP's office.
Any
Cannot do that. You have to
Ma'am.
serve and come back. If it is served, I'll request, Mr. Dev.
my lord,
Since there's a change of panel,
my lord,
you have to serve the GP's office once more. I'll take this on record.
my lord.
Please serve and come back.
Lord, then, my lord, I have to serve the entire copy.
No, serve serve a
Only
notice.
notice.
Yes. Entire copy.
Entire copy, my lord.
The old person doesn't hand it over to the GP office. He takes it home.
So, my lord, and my lord, then I have to serve 2 copies, each 2 copies.
Affidavit of exception used by the petitioner through the report in the form of affidavit submitted by the state respondents is taken on record. Paragraph, none appears for the state respondents. Paragraph, since there has been a change of learned counsels in the state panel, the petitioners are directed to serve the office of the learned government leader afresh and file affidavit of service on the actual date. Paragraph, let the matter appear under the same heading on 15th September.
15th September, short date, my lord. First week of September, my lord.
Very well, 8th September.
8th September, my lord.
Please serve in the meantime.
My lord, my lord. I shall serve.
Yes, next.
14,
No.
14, my lord. I beg to appear on behalf of the petitioner. Kindly refer to.
That matter.
We are suffering. I am suffering a lot, my lord.
My lord, I apologize because I was supposed to file a supplementary affidavit. My lord, the only predicament which I am facing is, my lord, the person who is to come and affirm, my lord, there is some medical emergency in his house. So for which he has traveled to his native village. So I was just beseeching your lordship to grant me 2 weeks time, because by then I am told he will be back and affirming, and I will also give an advance copy to my friends.
My lord, only one thing, my lord. My application can be heard, my lord, because I am filing an independent application for vacating of.
Before she
my-
is added,
my
or
lord,
not added, I cannot pick up any other application. That's the law.
if your lordship,
And
My
there
lord.
has to be a further extension.
my lord, the difficult issue, lordship, let my application is pending, lordship, only one thing, lordship, my 26 subsection 2 proceedings, lordship, hampered, lordship, because neither my client, lordship, participate in the hearing, lordship, they only, lordship, served a notice with a threat of the contempt. Lordship, I am suffering, lordship. On because of this, my lord, I am suffering. Lordship, as far as my knowledge is concerned,
that-
Lordship's order is never, Lordship, restrained us to initiate the proceedings under section 26 of
Why initiating proceeding?
because Lordship, the difficulty is, Lordship, they served a notice, Lordship, with the threat of the contempt, my lord. So they are the officers, my lord. If Lordship, my learned friend on the next day, Lordship, file a contempt application, my officer would be the alleged contempt now.
Order about.
My lord.
My lord, not,
Interim order say.
My lord.
Restrain from taking any coercive action.
My-
against of the plot in question.
Yes.
My lord.
yes.
Kindly see, Lordship,
And
there
my lord,
later.
Coercive action.
That notice also, my
Order.
My lord,
lord,
that is
that
the
notice
issue.
also
my lord.
under challenge.
Aware of,
My lord,
cannot
if
interpret
that
order brought for
only, my lord, this portion, Lordship, kindly revisit and Lordship rectify these portions, Lordship.
My lord, that
Only
notice
these
also
portions.
under challenge. That
Which
notice, section 26 moral notice.
My lord,
No, no, the
only,
interim order is not to take coercive action.
Yes.
my lord.
So the hearing can be there.
My lord,
based on the
my lord,
26
kindly
notice.
appreciate one thing, my lord.
They can proceed with the
My
hearing.
only
My lord,
these portions
My
of
lord,
kindly
they
record
say,
it.
my lord, when they have used affidavit and application filed, they have disclosed their stand, my lord, they say, my lord, this is the land belong to the National Highway Authority. And my lord, in their affidavit, my lord, they say, my lord, this stockyard has not been handed over by the state authorities to the National Highway Authority. In the self-same affidavit, they say so. So, my lord, this is it. Now it is a question. And for which, my lord, whether they can issue this notice, that also under challenge before my lord, by way of supplementary affidavit, because after filing of this application, this notice comes. So we have challenged those notice, two notices, same notice. And my lord, now in the affidavit, my lord, initially they say, my lord, we have encroached 10,000 square meter. After that, they say, my lord, 4,000 square meter. Now in the affidavit, they say a single portion. My lord, what
But
is their
that
stand?
that is the Lordship.
And
Let them
everything to be-
appear, Lordship. Let them appear.
Everything
heard.
to be decided.
Challenge to the notice.
Yes, my lord. Yes.
Through the supplementary affidavit, Lordship, they
Yes.
filed.
Supplementary affidavit, my lord?
Yes, supplementary affidavit.
Yes. There are 2-3 supplementary affidavits, my lord.
2-3 supplementary.
Yes, my lord, because after this.
No, my lord, this is
Second.
supplement.
Two to one.
I can.
একটা supplement. No, but only one, my lord.
দেখি কোথায় অনেক কাগজ এটা কবে হয়েছে
তোমার এখানে।
আমার তো
Yes,
একটা তোমার দিয়েছে। Where are your 2-3 supplementary affidavits?
No, my lord, only one, my
one,
lord.
right.
These are all applications.
Yes, my lord. One is from my side, one from a learned friend's side.
Yes.
One, I believe.
Before that, Lordship, kindly come to 41, page 41 of my CAN applications, Lordship. Lordship, once, Lordship, we served a notice for appearing before us, Lordship, to complete our proceedings. Lordship, they, Lordship, CAN 2, Lordship, my application, CAN 2.
Can 2.
That is, Lordship, the vacating. Lordship, kindly come to page 41.
এখন added হয়নি, আমি কিচ্ছু বলতে পারবো না।
Page 41, yes.
And Lordship, the second page is, Lordship, that is the notice, Lordship, they served to my project director, to Mr. D.K. Chaudhary, Lordship. And the next page, Lordship, that page 42. That is, Lordship, the page para 5, Lordship. If your Lordship kindly allow me to read, my lord. That since your earlier aforesaid notice dated such and such has also been challenged in the writ petition by way of supplementary affidavit, and upon perusal of the same, when the Honorable High Court was passed the said interim order, which is valid till 30th April 2023, and when the Honorable Court, by granting the aforesaid interim order, is adjudicating the entire matter, reissuance of the above referred notice, such as is nothing but an attempt to flout the Honorable Court said solemn interim order dated such and such, in as much as the reissuance of above referred notice dated at is itself is a coercive action in respect of plot in question with regard to the petitioners, my lord. Lordship, our hands is tied, my lord.
Yes, my lord, because my lord, already we have challenged. My lord, the fact is,
Where have you challenged the notice?
yes, my lord, that is there, my lord. Supplementary affidavit first.
A notice is issued for hearing. How can that be a coercive action?
Grateful, my lord.
My
That
lord,
is my
my lord,
question.
one thing, my lord, when they have disclosed, my lord, kindly appreciate.
Why
Let me,
can't the proceeding continue? That is my question.
my lord, how they can say, my lord, we are the, my lord, encroachers, because upon paying the rent revenue to the government, my lord, we are, my lord, possessing the land since 2007. And my lord, soon after taking the last money, they issued the notice.
Lordship, they can say this before us, Lordship, in the when. Yes, my lord, at the time of the hearing. Lordship only served notice and appeared before us, Lord. That does not mean, Lordship, we evict us, Lordship, evict them.
My lord,
It only a
when, my
proceedings.
lord, they have disclosed their stand in the application, my lord. My lord, kindly allow me. আজকে জুনিয়রটাও নেই।
Let the hearing continue, Mr. Betal.
My lord, one thing this is my
Hearing
lord.
doesn't mean coercive action.
My lord, may I, just one moment. Actually, the advocate on record has not come.
My lord, from my learned friend,
Getting-
since your lordship was searching, my lord, perhaps this is the supplementary affidavit. My lord.
No.
My lord, two, there is, second one is this one, my lord, affirmed, my lord.
কত তারিখ বলতো? তারিখ?
No,
No, এটা আলাদা।
এটা-
my lord, affirmed on 3rd February 2023. It's a very, very lean affidavit, my
This
lord.
is 27 February 2023.
And 3rd February, one is
Thereafter,
there.
3rd February was,
February is also my subject.
and before that I find here is 3rd February from my learned friend's
Yes, yes.
document,
3rd
because I
February.
don't have.
Two affidavits have been used, my lord, supplementary affidavit.
But my lord, I just perused it, my lord, for the sake, because what my learned friend was submitting, I find that they have not challenged anything, my lord, just have
In
an
the
extra.
supplementary affidavit also, there is no challenge.
My lord, only their Lordship annex this as a part of this. Can you take this as a part? They only annex because
My
that
lord,
has
may
been.
I just hand over my learned friend's copy to your lordship
I'll
for
just
pen,
find- I'll just-
so that your lordship can find it out.
Yes.
দাও তো একটু। একবার দাও দিদি।
What are these memos that are challenged in the petition? 12th December, 28th December,
Yes, my lord.
6th,
That is the
6th
my lord,
January.
the main issue. The temporary, my lord, the permission was given to the petitioner to use the government land on rent. Thereafter, my lord, they have not paid. There are some outstanding dues, several notices are issued.
No, time to time, my lord, I dispute. Yes.
Outstanding was there. Now, my lord, there is a clause, as and when it is required, they will vacate the government. They have not vacated. Accordingly, notice has been issued, they have challenged that. Now, my lord, it has been, it appears from thereafter, my lord, the land has been handed over to the National Authority of the Substance. My contention is this, my lord, some portion of the government land was allotted to the in favor of the petitioner to use the land on temporary basis for construction of medical college and bituminous hot mixing plant. But they have encroached other portion of the national highway,
My lord,
and accordingly they have issued the notice.
my lord, the main grievance Lordship between the Lordship, the learned Lordship between the petitioner and Lordship between the state Lordship. My case is only little portion Lordship. They have been encroached, and on the basis of this Lordship, we served the notice under section 26 subsection 2. And Lordship, they cite over this issue Lordship on the plea that Lord, this matter is subject before this Lordship.
Where is your notice under 26(2)? Is it part of the?
Lordship, they filed Lordship in the form of the supplementary affidavit.
My lord, page 11 of my lord, first supplementary.
দিদি কোথায় গেল? এটা দাও।
It's in the
Page
second.
My lord,
First-
3rd February, my lord,
3rd February supplementary affidavit.
is what I find, my lord.
3rd February supplementary affidavit. দেবো?
আমি তো নিয়ে
Lordship, on 24th March, Lordship, we served
আমিও
for asked them to appear before us for hearing.
আমি হচ্ছে তো আমাদের user.
Subsequent.
আমরা
This
sub-
notice is not under challenge anywhere in the.
Yes, my lord. Yes,
Yes, where is it?
It's just a next, my lord.
What
That's
is
what I
that annexed on?
gather.
Only annexed.
my lord. Second affidavit, my lord.
Neither. That's
Second
eight.
affidavit only.
Yes.
Let me time not.
Second affidavit, yes, please find out.
My lord, either there has to be a specific government or a
Yes,
prayer.
yes.
Because if they are challenging a notice,
I'm coming.
has to be a prayer, my lord. Has to be a prayer. And that has to be by way of a subsequent application. They are just
So Mr.
clubbing it.
Mehta will be contemplating a
My lord,
And only
this
their
is the-
prayer lordship, this supplementary affidavit must be a part and parcel of this writ petition. Only there,
That's
these,
all,
that's all,
yes.
that's all.
There is no prayer
No, madam.
challenging this
No.
notice.
My lord, after filing of this writ petition, we have come across this notice. So, my lord, by way of,
Annex the notice to the writ petition. You
my
have
lord,
not made any.
my lord, initial main issue we have challenged. These are the subsequent events. It can be, my lord, in writ court, my lord is well aware, my lord, the prayer which has been prayed in the writ petition and which has been subsequently followed, that can be molded, my lord, by my lord, when my lord decides.
Challenge?
Yes, my lord, I have brought those documents on record. So, my lord, these are the consequential action. If the state government could not have cancelled or issued the notice.
Memos, I want to see what they are. 12 December, 28
Yes,
December,
yes,
6
yes.
January.
Yes, my lord, I am coming. খুঁজে পাচ্ছি না।
Page 64 of the report.
12 December.
Yes. 12 December, yes. Page 64.
Annexed P10.
This is the government.
My lord, kindly, after this page, my lord, kindly have a look to page 61.
61.
This is served by the National Highways.
No,
No, my lord.
All
Executive engineer.
Yes.
Yes,
Is the other.
under the
other,
state, my lord.
my lord, kindly have a look to page 61 once.
Where is the memo 28 December?
Yes, my lord.
December, my lord.
Page 69. Page 69.
These are all by the government asking for surrendering possession.
My lord.
Yes. And pursuant to which, my lord, the sections 26 notice have been issued.
No.
Because,
My lord, no,
That's
no.
yes, my lord, that is, I will show from record. I will show from record, my lord. I will show from record. My lord, kindly have a look to page 61 once.
I will not go into merits now. Interim order has to be extended, but the interim order will not preclude the National Highways Authority from proceeding with the hearing.
My lord.
Only no coercive action. That's the, I don't know why this order needs to be
Modified.
said.
My lord, only because it's a notice, my lord. Once they serve the notice with the
My lord,
contempt of the threat.
My,
The National Highways.
my lord,
Yes, my lord.
my lord,
Every time, my lord. And lordship knows because of the small encroachment, lordship, the entire project has
My
been
lord,
stopped.
no, my lord. I seriously oppose, my lord. Why I say, my lord, kindly have a look.
তুমি শুধু কাগজটা নিয়ে রাখো।
My lord, the substratum of the entire fact is, my lord, there was an allotment which was given by the government of West Bengal to the petitioners. Now, my lord, that was a limited area. What they did is that they took over possession and started encroaching. Now, this encroachment which happened was basically the land which is belonging to National Highway.
National Highway.
Now, they are actually conjointly holding to, state is saying this possession is bad, and obviously the encroachment ipso facto is bad.
What they land.
My lord,
And now,
my lord, we
Mr.
have not.
Mehta, he is actually
My
lord,
entire project has been stopped.
My lord, may I say, my lord? May I say, my lord? For from 2007, we are occupied.
I'm not on that
My-
at all.
my-
Your
what-
occupation
what-
is
what-
not disturbed.
Yeah, my lord, may I say, my lord? May I conclude? They said, my lord, they say everything, my lord, anything against me, alleging that we are encroached.
We have nothing against you. Matter at all on merits now.
My lord, kindly bear me for a minute. From 2007, what was the position we are occupying that? That position was handed over to us by the state authorities. And my lord, kindly have a look to the affidavit.
Not have a look into anything.
And my lord, they say, the National Highway Authority say, this stockyard has never been handed over by the state authorities to the National Highway Authority. In their affidavit, they say,
Of course, I said.
para 9, they say, and now they are saying we have encroached.
Lordship can,
They
if
say
the.
the stockyard, you have encroached land beyond the stockyard.
No, not at all.
It says lordship,
Because
that is
my
the
lord,
adjoining part.
What will be decided by the court?
my lord, So
And also, my lord, the
that
fact.
is to be, when my lord decided to be this court, then how the authority can proceed with section 26? Because they will decide the same issue. Well, my lord is insisting over the issue. This is my respectful submission.
I am not insisting over that issue because 26 notice has not been
Because-
challenged before this court.
My lord,
You have no prayer challenging this notice.
my lord, in their affidavit,
Here continue.
my lord, in their
Order
affidavit,
be passed.
my lord, in their affidavit,
Without
lord-
the leave of the court.
my lord, my lord, one thing, my lord, in their affidavit, my lord, before passing of any order, my lord, kindly have a look to page 9 of the affidavit used by the National Highway Authority. On the basis of their submission, my lord, is
National Authority, what affidavit have you used?
Lordship, that is a can, Lordship.
can one,
That
can
is
one.
Can
Can
two.
Can.
Can two.
Can
Can
two.
one is my
Oh,
application.
can one, can two, yes, it is can two.
Page 9.
Page 9, para 9.
Yes.
It is submitted that main dispute as raised by the petitioner is related to the
Yes, no
stockyard land,
dispute, Yes.
which has no concern with the applicant NHI, as the said stockyard land has not been handed over by the PWD.
No dispute, yes, that is the submission.
We are occupying this stockyard. Now they are coming with a plea saying that we have encroached some portion. And what is the notice? My lord, kindly have a look to the notice. First affidavit.
Lordship, the
First
other
affidavit.
portion.
May I,
should be
my
referred to
my lord, they say everything. My lord, now my lord.
Well, we have said, Lordship, that they are illegally occupying the right of way,
Beyond the
Lordship.
My lord,
Because of
kindly,
this, we have suffered.
how these things are coming? How these things are coming? My lord, at the instance of the intending, my lord, the party, my lord,
Because I am also suffering, my lord.
kindly have a look to the page 9 of the supplementary affidavit dated 3rd February 2023.
Yes.
This is a letter issued by, my lord, the agency to the project director.
Yes.
What he has referred, what he has stated, my lord, can be have a look. Maintenance, operation and maintenance of Kolaghat, such and such. And kindly come to reference. Last letter, it is of dated 29/6/2022. When we are, after that, we have paid rent to the government. And in the letter, my lord, kindly have a look,
That is your.
That is not
petition.
the, yes.
National Highways is not
No,
concerned.
Yes, my lord.
what prompted them to say, that is to be decided, my lord. To be decided, my lord. That is why we said, my lord, we will not participate in 26 proceedings. My lord, kindly, I read, my lord.
Ex parte order.
My lord, I read for my lord. Dear sir, we are concessionaries of the above project with reference to the above referred letter dated such and such. The concessionaries had requested to the authority for immediate review of the encroachment and issue notice to encroacher so that encroachment can be removed at earliest. It is also requested to communicate this critical issue with DM and SDO for their administrative support. Hence, the concessionary are also requested to the authority that previous correspondences of the executive engineer, Public Works Department Directorate, National Highway are collected rent from the encroacher, HM Construction. We are the writ petitioner. Only within 4,342 square meter land and the amount of rupees such and such. But actually the encroacher are occupying 20,800. We do not know. Where from he got, my lord, we do not know.
Why are you
My
concerned?
lord, we are concerned, my lord, we have only occupying what we have been allotted, that is 4,000 and something. My lord, then my lord.
Where is that allotment? You will not be disturbed in that area. Where is that allotment? 4,000 something? Where do I get it?
My lord,
Document?
may I conclude this letter, my lord?
Not
Therefore,
necessary at this stage.
my lord, kindly appreciate. Because my lord, when my lord is directing us to participate in the proceedings, that is why I am saying. Therefore, the consensus are requested to the authorities. Please note that encroachers are covered at a square meter, 20,800 square meter. Similarly, the actual figure is such and such, 25,34,000 and such and such. Hence, concession is requested to authorities to please collect the balance amount. Who is he? Whose instance this proceedings is going on 26 proceedings. And my lord, he says, we are occupying 20,800. Whereas we are occupying, it is our affidavit, also we have stated 4,000 odd, which have,
Stated, I want to see that.
yes, ma'am.
You will not be disturbed in your 4,000 and odd occupation. Beyond that, the court doesn't take responsibility.
Yes, we have, that is,
They will
this
have the
much,
right to
this
reject
much we are paying.
Beyond, my lord, that portion will be taken away by the highway.
Yes, my lord.
Let that
Please
be
show me
the.
the exact area given to you on rent.
This stockyard have been given.
Yes, my lord.
This
That is the
stockyard.
case, my lord. This is
That
the
is
case
this
of
stockyard.
stockyard, lordship.
Measurement of
And lordship,
stockyard.
our land is just adjoining the
The
stockyard.
area of the stockyard.
The entire huge portion of the stockyard.
And they collected rent for this particular, yes, yes,
They
yes,
are not
yes.
concerned about
Yes,
this.
ma'am.
My lord, page 54, I just took a
Of the
peep
writ petition.
of the writ petition.
তোমার হয়ে মামলা করে দিচ্ছি।
I just took a peep into my learned friends.
54.
54, my lord. And thereafter 55 and 56. My lord, it's the rate are decided and everything. There's a table.
Yes, page 39 also there. The area. This has been issued by the government. Page 39, my lord, kindly have a look. কত হয় গুণ করলে?
গুণ কি করে করবে?
আরে দাঁড়া না রে।
আরে এটা তো তোমার ওল্ড রেট, তারপরে এটা
হ্যাঁ।
রেটটা পরে।
রেট তো টাকা কত দিচ্ছ?
What should be the relevant document?
54, my lord.
You're also trying to change my lord. Page 64.
64.
The notice
I
is
want to see
specified.
the area.
Yes,
My
page
lord, the notice
56.
specifying that figure.
Page 56.
Page 54.
56 also there, my lord, 4,000,
Yes.
4,300.
Area 434 square meter capacity.
Yes,
342 square meters.
Yes,
You will not
we are-
be disturbed in that area.
yes, yes.
And
That
if
is
you
my,
hear
that is my case.
found
That
that
is my
they
case.
are enjoying anything.
We are seeking
even
only,
one
we are seeking protection only on that land, not 10,000, 12,000.
Not if, only this will be.
Yes,
protected.
My lord,
yes.
if that
What is
lordship
your,
kindly come to
notice?
page 30, my lord, page 30
And
of
my lord,
my
they say, my lord,
application,
may I
can
conclude page 10 of the my supplementary, let me complete. In view of the above, executive engineer NH division 2 has already served notice. Each and every notice was prompted by this person at their instance. And in this specific affidavit, my lord, they say, my lord, in application, this stockyard has not been handed over by the state authority to the National Highway Authority.
Because you are
So,
encroaching
my
the
lord-
adjoining portion of the stockyard.
No,
Yes, that is.
whatever we have been,
Two, you will not be disturbed.
yes.
My lord, before that, my lord, only one thing, lordship, if your lordship kindly come to page 8 of my CAN applications, lordship, because the entire stretch has been mentioned, lordship, because this kilometer 37.210, lordship, that is the main concern. If your lordship kindly come, page 8 of my applications, lordship.
Yes.
Page 7, para 7, lordship, it is submitted and brought on record through the present application before the honorable court that an area at measuring approximately 18,000 square meters comprising of plot number such and such at a kilometer situated within the national highway right of way has been transferred to the applicant national highway by the Public Works Department, Government of West Bengal, vide such and such. In this regard, it is submitted that Executive Engineer NH Division PWD vide memo dated such has handed over the complete stretch, that is 41 from kilometer 52.700 Kolaghat to Holdia to National Highway for construction of 4-laning work, which including the subject above plots, lordship, that is the 37.210 left hand side. After taking, my lord, this is the concern, lordship, after taking possession of the said stretch, including the above mentioned plot land from the PWD Government of West Bengal, the applicant started the work then itself and has completed the subject work. And lordship, then lordship kindly come to page 30. That is the notice has been issued, my lord.
And what's,
Yes.
My lord, that this is a notice, lordship, for removal of unauthorized occupation, whereas I, Sri D.K. Chaudhary, such and such, on periodical inspection of the highway land, on the information received by me, am satisfied that an unauthorized occupation has taken place on the highway comprised area of 20,800 square
This is
meters.
issued to all
Yes.
the encroachers.
Yes, lordship.
Including the petition.
No,
Yes, no, lordship, this.
no, this was issued to me.
No.
20,000, we are not in occupation. Where from they are saying?
Not in occupation.
My
not
lord,
in
what,
concern.
no, my lord, what from they are saying? At the instance of the agency.
No,
Agency in
How?
2000, in, my lord, I have shown the document, my lord, the first epidemic.
You will not be disturbed in regard, with regard to your
Yes.
4342 square meters.
Yes,
that's all.
we have no
Beyond that,
difficulty.
You have no authority.
No, we did not say even. We are not occupying 20,000. My lord, what,
Lordship, this is-
and
lordship,
this notice says, my
after
lord, on
inspection,
periodical.
lordship, found that these 20,008 square meter has been encroached by by my friend, lordship.
You need a demarcation for this.
Lordship, if you lordship then pass this order, my lord, I am ready. I am ready, my lord.
Going to merits without allowing her to speak. I have to consider.
Lordship,
her
because of
application
this, lordship, otherwise, lordship, only,
not preclude you from continuing with this hearing.
this portion, lordship, kindly
Only the
mention.
petitioner's portion will not be touched.
Yes, we are seeking only that.
Okay.
And also, my lord, if mentions that the hearing will continue
Yes.
of their hearing, my lord, National Highway.
My lord, first, my lord, state has to, my lord,
Learned counsel for the intervener seeks accommodation to use a supplementary affidavit annexing relevant documents. Paragraph. It is submitted on behalf of the National Highways Authority of India that due to the interim order passed by this court, the authority is unable to proceed with the hearing pursuant to notice issued by them under section 26 within bracket 2 of the Control of National Highways within bracket Land and Traffic bracket closed Act, 2002 on 16 January 2022. 2023, 16 January 2023. Paragraph. The interim order granted on 3rd February 2023
it is already there in plot in
envisages
question.
that the respondents are restrained from taking any coercive action in respect of the plot in question with regard to the petitioners till 15th March 2023, the said order being extended from time to time. Paragraph. The petitioners claim to be in possession of an area of land comprising 4342 square meters
At Kapasgeria Stockyard. Kapas area. Kapas area Stockyard. Stockyard.
Under Tomluk NH subdivision of NH division number Roman 2, PW within bracket roads directorate. Stop. It is submitted on behalf of the petitioners that the petitioners do not claim any other land beyond the said area. Stop. Paragraph. A notice under section 26(2) of the Act of 2002 has been issued by the National Highways Authority on 16 January 2023 upon unauthorized occupants of two 20800.00 square meters situated at KM capital 37.210 LHS of NH 41. Stop. Paragraph. Since the petitioners claim right in respect of 4342 square meters of the Papasaria stack yard and not beyond, comma, the interim order granted in favor of the petitioners claim, since the petitioners shall not preclude the National Highways Authority to proceed with the notice dated 16 January 2023. Paragraph. Let the matter appear under the same heading on. That should be sufficient.
My lord, that should be, I'm grateful, my lord.
On, because I do not want to go into merits further.
Yes, ma'am.
On 14 September, paragraph, it is made clear that in terms of the interim order, the possession of the petitioners in respect of 4342 square meters, as stated earlier, shall not be disturbed.
Grateful to my,
Much obliged.
grateful to me.
Because that is subject matter of the report.
Yes, well, that is subject matter.
Disturbed until further orders. Disturbed until further orders. Or you can take back your record. You too. Well, that is the one. This is the one. Yes.
My lord, interim order extended up to, my lord.
Actually, line add to interim order. 30th September.
30th September.
ওই যখন it is made clear বললাম তার আগে
14 তারিখে
it is made clear বললাম তার আগে the interim order granted earlier is extended till 30th September or until further orders, whichever is earlier.
My lord, can it be on 18 or 19, my lord, instead of 15 September?
Very well, 19.
My lord, before, my lord, before 14th, my lord, because lordship before 14th.
My lord, if it is not affirmed.
তোমার affirm-
ও তো অ্যাপয়েন্টটাও লাগবে।
Very well, my lord, we shall come back on 19.
19th.
And
Grateful to
please
me.
serve an advance copy. to
Yes, yes, I shall, I shall. Much obliged, your lordship.
Next.
10,
Much obliged. your lordship.
But I'm for the, but I'm for the petition.
My lord, in this matter, there's a direction in your lordships to file affidavit. Affidavit is already ready, my lord. Already ready act completed. My lord, I'm for the state. My lord, only difficulty is this affidavit already in custody in the advocate Devbhupio Chatterjee, and for certain reason he's out of service. Only make it tomorrow. Tomorrow it will fly. It will be filed. Only make it tomorrow. It's a humble prayer.
I'll give you a short read. On learned counsel for the state respondents seeks extension of time.
They have served me advance copy of the affidavit.
They have served to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 8th September.
My lord, obliged, my lord.
Much.
16,
My lord, I am appealing on. My lord, on 19th July 2023, my lord was pleased to pass an order. Kindly see the my lord's order.
Yeah. Who is appearing for the ECL?
ECL, my lord. So is Nurul Arfin.
CL wanted to file a
লিজা,
report.
তোমার কিছু বলার আছে?
এখানেই ছিল তো।
আমি তো আগের দিন পরে এসেছি যে দেখিনি।
Where is the learned counsel?
There is no report filed as.
Where is learned counsel? He is also not there. ECL is the answering respondent. I
Yes.
think, the main answering respondent. Difficult.
এই নুরু আমাকে ধরেছে, এই নুরু আমাকে ধরেছে।
ECL টা ধরেছে। হ্যাঁ।
The board is
The matter is
showing,
stated, board is not functioning.
it's functioning, but it's showing 15, item 15, my lord. It's not our item 16. But here, my lord, I have five, your lordship directed us, my lord, to file report, my lord. My lord,
Have you served a copy?
no, I'm giving. My lord,
Advance copy that we served.
yes, put it, my lord. Sorry, my lord.
ওটা অ্যাডভান্স কপি দেওয়ার কথা ছিল।
Sir, query হয়েছিল। It was, my lord, your lordship, no
Petition
CCL.
you acquired the land and you
Madam.
say you have purchased.
Yes, purchase, my lord. I have annexed, my lord, the say, registered deed, my lord, also the record of right, my lord. And my lord, I have also annexed the relevant clause, my lord, which, my lord, it has come to us, my lord. But if your lordship turns, my lord, to kindly go through the report, my lord. My lord, first, my lord, the arrest record of right, para 6, my lord, I say that as per para 101, the name.
কত পাতা দেখাচ্ছ?
Exception given,
হ্যাঁ?
আজকে করবো না।
না না আজকে করবো না।
তাহলে বলুন, তাহলে time দিন,
হ্যাঁ।
তাহলে আমি তাহলে করবো না তাহলে মামলা।
কি করবো না দেখো নিজের। Just একটু বলছিল।
Okay, but kindly see, my lord, para 6, my lord, I say, my lord, the arrest Porcha 101 is in the name of Birodini Hemram Kode, the son of such and such, my lord. And then in the record of rights, my lord, the plot number is, my lord, 645 total, my lord, which is the concerned plot, my lord. Second, my lord, I say that subsequently, Simoni Devi, wife of such and such, my lord, had purchased plot number 645 from the plot number of 54 acres and was in possession of the entire said plot area. I say, my lord, that Subhasini Devi has also holding plot number such and such in the area of such and such, the possession, and the said Subhasini Devi has sold the entire land to the Aswile Coal Company, that is Bengal Coal Company, Saktoria such and such, having his head office, my lord, address is given, my lord. My lord, that, my lord, has been recorded, my lord, in cell deed number 4418, the book number 1, volume number 442, page 121 to 128. That, my lord, is annexed, my lord, as, my lord, R2, my lord. First, my lord, I showed, my lord, who was,
54 is the entire plot.
my lord, the 4412, my lord, is the where they are casting, my lord, that is there, my lord. In which they are asking for for their title, my lord. Before that, my lord, we are showing that we have purchased this, my lord. The title deed is also annexed, my lord. Now, my lord, thereafter, my lord, after Bengal Coal Company, my lord, your lordship knows, my lord, this, my lord, I say.
Not related with me, my lord.
Why not related?
To the petitioner.
Yes.
Petitioner is only, my lord, acre 0.54 acre.
Yes, but I have
0.54
purchased the
Inter
entire.
stadium, my lord, Inter stadium, my lord, kindly see.
But I have purchased
page-
that
page
total
P3.
full lot, my lord.
Page 25. This, it is a
The
stadium.
entire plot is 54 acres. That is the entire plot number 645.
645.
The entire plot is 0.54 acres.
54 acres.
54 acres, but my land is only 0.54 acres.
That is 0.50. That's
That is my land.
They have purchased it earlier, sir. Please see the deed.
It has been
If you want to use an exception, you can do.
Yes, yes, my lord.
Yes.
Yes.
Let him come back. Let him come back with an exception.
নামটা দিয়ে দেবেন, নামটা।
Report in the form of affidavit submitted on behalf of the ECL is taken on record. Paragraph learned counsel for the petitioners seeks to use an exception to the report. Paragraph with the matter appear under the same heading on 14 September.
What is it?
Please serve an advance copy so that.
I've already given him copy. I've given it. But your lordship knows ECL, my lord. Here, my lord, I have to inform that parcel will come, then that parcel will.
No, that person,
We
that
have
is
to-
united from since, my lord, 1950.
ও বাবা, ওইটা
No,
বলছি
no,
না।
in case of an
ওটা
authority.
বলছি
It is
না। Why delay
what-
manner in
what-
filing report? That's why I'm explaining that. Deeply appreciate.
Yes, next.
17,
Lordship, in this matter, Lordship, I am for the petitioner, Lordship. Lordship, no,
In this
every
matter, I have filed the
Lord-
CAN
Lordship,
application for
one thing,
addition of party.
1 minute, 1 minute. Lordship, earlier occasion, all the parties have filed reports and I have already filed reply, Lordship. But suddenly, on last occasion, again, second time, another report was filed that one-man committee, Lordship. Some documents is required to file the reply, Lordship. Kindly give me some adjournment, Lordship. I need at least 15,
In the
20 days,
meantime, my lord, my
25 days time
application-
to file that, collect the documents and file the reply, Lordship.
A CAN application is pending. Do you have?
Yes,
the
yes.
option to do it? Have you seen the application for addition of party?
Yes, Lordship, actually, my learned senior, Mr. Sushant Kumar Mukherjee is appearing in this matter. He has instructed me to pray time before your Lordship for the purpose of filing reply to that second report.
What about the application for addition of party?
Negib থেকে দিয়েছি। ও না,
I, yes, Lordship, yes, Lordship, yes, Lordship, on the same day.
পাইনি, দিয়ে দেবো আমি দিয়ে দেবো।
Let her come back on the next day.
Lordship,
In this CAN application, I filed the CAN application on behalf of the depositors because they are the in the event there is any order passed, the depositor will suffer. The only question is that whether this court has because the special bench is there, so far as the Ponzi matters are concerned, my lord, whether this court has can take up the matter or the matter will be referred to the.
No, it is not.
So, my lord, that can be referred to.
Not ready today. Let
Very
her
well,
come back.
very well, madam. I am not.
kindly give me at least 15 to 20 days time, Lordship, minimum.
Pair of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 20th September,
Yes, yes, Lordship.
20th September,
20th September.
more than what you asked for.
Yes, Lordship,
Yes.
thank you. I'm obliged, Lordship.
Next,
In the meantime, my learned friend will file my reply of the
Lordship,
petition.
22nd September,
20th September.
20th, Lordship.
And if necessary, I can also file my reply,
Yes.
madam.
I'm obliged.
You still do not have locus, sir.
Yes,
Please be added first.
yes, that is true. If any affidavit is filed, madam, then
You are not entitled to a copy at the moment.
so far as
Be added,
the affidavit in
not to the writ petition, not the application.
CAN application.
It's an exception to the report filed.
Oh, very well, very well.
18, I am for the
18.
petitioner, my lord.
But I'm for the S1 number 3, 4, and 5, my lord. This matter was earlier released by your lordship for the grant of
On
determination.
15/5/2000.
Assigned.
জানি, এই তো আজকে উঠেছে।
assign, no?
This is petroleum and mineral pipelines.
Yes, yes.
Which determination then?
My lord was of the view, my lord, this should go before the group 9. May.
Group 9, madam.
The chief justice has sent it, let us hear it. No difficulty.
Very well.
Yes, yes. The petitioner prayed
The
for,
master of rosters, so if he has decided,
yes, yes.
who is appearing? for the
Yes, yes, I am.
respondents?
I'm for the
Petitioner.
respondent number 3, 4, and 5.
Others? Union of India,
The children.
Others, my lord, Mr. Hemant Kumar Mitra, Union of India. Last occasion he appeared, my lord.
so you have to serve and come back.
Yes, ma'am.
It has been sent again.
Yes,
so
yes.
please serve and come.
Yes.
None appears for the Union of India. Let the matter appear under the same heading on 11th September.
Yes.
Paragraph, the petitioner is directed to serve notice upon the Union of India intimating the adjourned date.
Yes, yes. আপনারা এই তিনজন আছেন?
হ্যাঁ, হ্যাঁ।
হুম,
19,
চলো, প্রশ্ন উঠে আছে।
But in 19, Mr. Ganguly appears for state respondents.
Yes,
They will not,
petitioner,
but he is absent today. But kindly, may I file the reporting form or anything?
My lord, if your lordship, I'll turn to my application.
We need to add central document.
There, your lordship, paragraph 2. And the report, I am,
Give me a minute, please.
my lord, have received the report.
You've received.
Yes, I received it.
Why 2 reports?
One is by the special land acquisition officer. He said 9CB, 9C has not been done. So there is no proceedings according to their end. There is no liability to pay any compensation. And the executive engineer filed a report whereby he's saying yes, portion of has been utilized. So as on this date, the land has petition has been utilized without any acquisition process. Now I can turn to paragraph 2. Your lordship find there are 1, 2, 3, 4, 5, 6.
Paragraph?
Paragraph 2 of the writ application.
So they have admitted section 4, section 6.
In the report, they have said, my lord,
Oh, no notification under section.
no, nothing.
Both the reports say so.
No, this is the utilization report by they have utilized.
So it was utilized.
So it is admitted position that without an acquisition process, land has been. Now, my lord, if your lordship, I will turn to paragraph 2. 1, 2, 3, 4, 5, 6 plots have been mentioned where I have the interest. My lord, got it. Paragraph 2.
Paragraph?
2 of the writ application.
Yes.
My lord, got it. Now, my lord, can you consider the report once? Filed by the respondent number 6.
Lord, if your lordship pleases to hear the matter on merit matter, let Mr. Ganguly come and take up the matter tomorrow or any day.
That-
Then, my lord, next matter, my lord, mine. That is 20 and 21.
Let this be adjourned.
That matter we had. Our matter may be disposal. My lord, my lord.
Reports in the form of the.
My lord, so I also prayed leave to file an exception to this report. Also.
Reports in the form of affidavit submitted on the state respondents
What are you police?
are taken on record. Paragraph on prayer of the petitioner seeks to use an exception to the reports. Paragraph that the matter appear under the same heading on 11th September.
As a lordship, please. Within this period, my lord, I'll file my exception. This is my everyday service, my lord. Porish, my thing, no,
That is my lord, I find the report.
20.
Yes.
They should be on similar matters.
These are similar matters, but the report makes these matters dissimilar. Here, my lord, if your lordship can consider these are 2 plots of land which are involved. That paragraph 2, my lord. RS plot number 2974 and 2975. The petitioner is interested, my lord. Now, if your lordship can consider the report. Page 6, no? It is the portion, I think. Page 6. 2974 and 2975. My lord, got it. Second. 2, that is WP number. Partly used. So they are admitted both the plots are being used.
That is page 6.
Applies for embankment, yes.
Yes, ma'am. So, my lord, according to your lordship, we must purchase it or
Initiated processes are instead of the same plots of land, my lord. Previously, this is a matter which comes before this honorable court in 2014. This came up after exchange of affidavits, my lord. Ultimately, judgment. I earlier.
When it is admittedly utilized without acquisition.
There, my lord, what happened, my lord? This was done in the year 2013 or 2014. This utilization was taken place. Now the spar or the ring mouth is given inside some portion inside the land. Now what happened in the year 2013-14, these plots of land before that, because of why it makes dissimilar, page 6, my lord, your lordship will find these are the lands which remarks is under the river bed.
Page 6 of
The report, though it is not related with the petitioner's land, because the petitioner's land has been two plots of land, they have admitted their heritage. Why it makes dissimilar? Because of this. 2997, 2998, 300, 3001, my lord will find, out of which 3 has been mentioned as riverbed. Because now, my lord, the river is to some extent in the 2013, and due to construction of the bond, now the plots which are there in the existence 2013 has now gone under the riverbed. So that's, but they are saying it is cannot be considered. That's why they are in that judgment, my lord, it was held at the time of when you are utilizing the land, those plots were there. So today you cannot say those are under. No, that's because this makes this dissimilar. Otherwise, so this is concerned, my lord, they admitted 2 plots. They
have a representation before the authority.
No, combined representation was there, my lord. That your lordship will find page 22. All the land losers, along with the petitioner, made this representation. Sometime 2010, after that, my lord, probably nothing has been done.
Will you file a comprehensive representation?
As your lordship, my lord. And it is indicating this, my lord, so it can be.
Yes, it is admitted.
Yes, my lord.
One prayer, my lord, may I may. If it can be done, because other matter, my lord has directed the principal secretary, the person is now getting the compensation. Because executive was, so that latitude, my lord, I'm praying before your lordship whether it can be done or not.
Who will consider, Mr. Dev?
Because now everything is on record, only the decision
My lord,
making
now
process.
the executive engineer will send the requisition to the
Principal secretary.
no, principal secretary.
No, we routed
Special
over.
land acquisition officer. Special land acquisition officer to acquire the land. Or he purchase, my lord, he can purchase the land according to
এই
the.
পারচেজ গল্প হলে তখনই তো আলাদা হবে এখন আমার তো আর কিছু নেই এখন
My lord, your lordship can pass the order. I can't.
because today if lordship directs special education, they are saying the requiring body does not place any fund. Principal
All 3 be taken in the loop. 1, 3, and 6.
Yes.
The secretary, the special land acquisition officer, and the executive engineer.
Yes, my lord. First, my lord, requisition will be a proposal was sent by the executive engineer within.
So I'll direct all 3 of them to consider and dispose of the
Because it
representation
will,
Ask, my lord,
and take necessary consequential steps.
yes, my lord.
if this be done, my lord, all other matters will be resolved from this. This board is, because everyone will get the
Who will decide who will consider the representation? And all 3 of them cannot consider.
secretary.
The
Secretary, response number 1 is the appropriate authority. He has the higher authority in respect of the executive engineer and the special officer. He can direct them, but the special acquisition officer or the executive engineer cannot direct the secretary.
Who has to take the decision?
Secretary.
The secretary.
Purchase.
No, secretary. Hierarchy, the secretary is the highest.
No. যদি my lord, if the acquisition will start acquisition, my lord, then my lord proposal is sent to the executive engineer to the special land acquisition officer.
Yes.
Mr. Roy, let the special land acquisition officer deal with your representation.
Yes, my lord.
And consequential steps be taken by 1, 3, and 6. That should also serve the purpose.
It's because there's some higher officer.
3 of them cannot sit.
No, I am not on that.
Affidavit of servicing. Paragraph, report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph. It appears from the report submitted on behalf of the state respondents that
এটাও
Same.
না আমি ওইটার জন্য গন্ডগোলটা হয়েছে
land of the petitioners
কিন্তু হয়ে যাচ্ছিল এগুলো অ্যাডমিশন হয়ে যাওয়ার পর কি থাকে আমাদের
was utilized by the authority for construction of embankment
না এইগুলো যেটা করছে এগুলোতে আসা মানে তো
without
করতে হবে না
acquiring the same. Stop.
পরে
Paragraph, it is submitted on behalf of the petitioner that the concern
He has to say support in this report.
directing with liberty to the petitioners to submit a comprehensive representation before the third respondent within 15 days.
Yes.
Within 15 days from date. Stop. The third respondent is directed to consider and dispose of the representation within 1 month.
Yes, my lord.
Within 1 month from the date of receipt thereof. In presence of the sixth respondent and upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioners, in accordance with law.
And
Paragraph,
বলেছেন যশা বলছেন
paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof. Paragraph, upon disposal of the representation, necessary consequential steps be taken by respondent numbers 1, 3, and 6 within another 2 months.
Within 3 months, my lord.
3 months. I agree to that. I never argue because I know.
Within 3 months thereafter.
I have not disputed this for the time frame. I never dispute because it happens. But let me.
Yes, next.
Next similar one.
Arjun.
21.
21, my lord. Same.
Land is above water or below water? Underwater?
No, it is above water. It is still what happened? But this side,
It's, below water.
yes, because this side of the land goes to the river bed. This side of the land, which is utilized, is still alive. This is, my lord, your lordship can consider the report, page 5R.
Same order can be passed.
Same order.
Is there an affidavit of service?
Yes, sir.
Same.
8.
22.
Your lordship pleasure was that I should file a report, my lord. But I am sorry, my lord, I could not give it to my learned friend, my lord, on earlier occasion. This is the copy of the report, my lord. And my lord, this is the report. What are the answers?
The field verification is held.
Yes, the oil joint field verification.
And field verification has been made, my lord.
Appears to be the same issue.
I will check up only the plots number and the report. That is the I have reconciled. I'll come back because just my lord. Forgive me, my lord. Otherwise, I'll assist it.
The copy just now.
Because I am to verify this plots number whether
Yes,
inside the river or outside the river. না আরেকটা জজ সাহেব রেখেছে
Reports in the form of affidavit submitted on, no. Affidavit of service submitted on behalf of the petitioner and report in the form of affidavit submitted on behalf of the state respondents are taken up. Paragraph. Copy of the report is made over to the counsel for the petitioner in petitioner's court this day. Paragraph on prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on, what was the earlier date fixed in the?
ওটা কবে জানো 18 না এটা 18 ইয়ে কবে হলো ওটা মিসড 19 নম্বরটা দিদি কবে দিলেন 19 নম্বরটা 11 11
Let it appear on the same date.
yes
Lordship.
11
Appears to be similar.
yes same order only I have to check it out whether this inside or outside that is the only thing
11.
Lordship.
23,
রিপোর্ট আছে
হ্যাঁ
দাদা
দেবো একই তো রিপোর্ট সবই তো এক রিপোর্ট একটাই তো ফিল ভেরিফিকেশন
আরে ওটাই তো শুধু নদীর উপরে আছে না নদীর তলায় চলে গেছে এইটা দেখো মানে কি বিরোধ নেবে না
কি আছে বলাই করে না
না না আমি ওইটার জন্য না এখানে দেয়ার ইজ এ রিপোর্ট ওয়াই মাই লর্ড আই এম সাবমিটিং বিকজ অফ দিস
Same day.
same day it will be done.
3 plots are involved, my lord. Only 2 plots partly, my lord, utilized. 1 plot is not utilized.
So let him
river bed
river bed. Let him come back.
yes my lord that's why my lord
আগেরটার মতো same order. Copy made over in court this day.
11 হ্যাঁ 3টা 11 দুটো ডিসপোজ অফ
11 September.
11 সেপ্টেম্বর
হ্যাঁ, same is ready.
24,
otherwise they are not for adjourned only for that
এটা 24, my lord, I beg to amend the petitioner on the last occasion, your lordship was pleased to direct
24.
24, direct the petitioner to, my lord, submit the, my lord, site plan annexed to the deed. My lord, may I hand over the, my lord, photocopy of?
Mr. Lalit Mahato, for the state discipline, he is engaged.
Let a copy be given to us.
Well, another direction was there
On
for
our
filing affidavits of the reports.
Report, yes.
Well, only one issue was raised.
So asking for an adjournment today.
My lord, Mahato, Lalit Mahato engaged in code number 6, my lord.
report by us, my lord, yet to be filed, my lord. I missed that. Lordship grant us
As well as the state.
as well as the state.
Please come with the report on the next day.
Lordship kindly give us 2 weeks time to come with that.
Ready with the report, the state.
My
Learned
lord,
counsel.
we are suffering, lordship kindly appreciate only one issue, my lord. Without demarcation, how the, my lord, state handed over the position to the KMD? That is not clear.
He is always suffering. Even after 40 years, 30 years, you will come and say.
No, no, on the last occasion,
Correspondence seeks accommodation, seeks extension of time to submit reports in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 8th September.
my lord, kindly record that I have complied with the direction of your.
How can I record? It should come by way of a supplementary affidavit.
Yes, sir.
Supplementary affidavit already filed.
So how can this be taken on record like this?
Another supplementary.
Another supplementary.
এটা ফেরত দিন।
দিয়ে নাও এটা সাবলি করে দিয়ে দাও মাছো
Madam, I am for the petition. Madam, I am for the respondent number 5.
Yes.
On the last occasion, the lordship directed the state government to file a report. The matter, but I will file an exception to this report. I have received the report.
It has not been submitted to the court.
The SUVRA Das.
Yes, yes.
Yes, where is the report?
Yes.
Totally contrary to their previous submission. This is the second round of litigation. Your lordship has passed an order for return of land. They have admitted that they will return. We have undertaken that we will not give any compensation before your lordship order. Thereafter, they told that they could not find the land. The land even after they conducted hearing, they told that we have
acquired entire land, we have paid compensation. In the report, they are showing under section 4 that they have acquired the entire land, but they have failed to submit any document that they have that 5 decimal they have paid any compensation. Some papers they have submitted in the report. Well, I will file an exception.
Malad, I am appearing for respondent number 5, the beneficiary, the Kishan Milk Cooperative Society. The land after required, the land was given to us. So we are running our cooperative society there.
But the original report is not with me. It is only a Xerox copy of the report, my lord. I'm sorry, pardon, it is lying with Mr. Ganguly, my lord. Kindly take up the matter any other day.
State respondents seeks extension of time
আপনাকে
to
copy
submit
দেয়া
the
হয়েছে?
report in the form of affidavit. As sought. Paragraph, learned counsel for the petitioner seeks to use an exception to the said report. Paragraph, let the matter appear under the same heading on 13th September.
Lords.
My lord, a copy of the report may be served upon me also for respondent number 5.
He is seeking extension of time to submit the report.
So on the,
Report is not
on the
filed
next
today.
date, my lord.
Yes, I shall, yes, I shall file.
13th September.
Yes.
My lord.
26.
26 or for 11 July 2023, there was a passed an order, and the learned advocate for the state submitted because the last 4 lines of the first paragraph.
Where is this?
Submitted on behalf of the respondent that payment of compensation in respect of the petitioner except petition 1, 3, and 9 and 10 has been initiated. Some anomalies being found in the cases of these 4 petitioners, payment of compensation so far as their concern could not be initiated. Then, my lord, it is proposed by the parties that the petitioners shall approach the authority being third respondent herein for payment of compensation as well as the correction of the anomaly depending on 20th July. The my lord fixed 20th July.
Ganguly is appearing in this report.
Can you listen to it? The petitioner, except 4 petitioners, other petitioners, after passing of the order, they received the compensation. But so far as 4 is response concerned, since no notice was served upon my client, the four petitioner, now they thought on receipt of the notice, they will see approach the authority. But your lordship fixed the time, 20 days. But they could not approach by mistake. By mistake. So what I'm submitting, you have to fix another day, they will approve.
Who is appearing for the respondents?
He has not come, my lord, Mr. Ganguly.
Mr. Ganguly has not come. Submission was made that he is busy in another court.
Yes.
I have come to just now, earlier matter, my.
Counsel said you said he's on legs before some other court.
Yes.
No. I have said he is absent today.
Please.
Taro Karan also there.
Mr. Lolit Mahato is engaged in another court. Their submission was made.
There are 2 lawyers.
You are not briefed in this matter.
No. My lord, Mr. Ganguly is sitting in my lord, he has not come.
Not today.
Make it not today. Not tomorrow.
Because only a date has to be fixed.
Only date has it.
Not today.
Yes.
27.
27 kindly short password my lord.
27 password না
Report দিবেন?
তোকে এই নে তোকে রিপোর্ট কে দিবি exception দিবি
But kindly 1 week attend reply.
they will file exception if they want
An exception.
Yes, my lord.
খালি হয়ে গেল টাইম দিয়ে গেল
Report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph, learned counsel for the petitioners seeks to use an exception to the report. Paragraph, let the matter appear under the same heading on 13th September.
Careful.
28.
My lord, this is my application, my lord.
My lord, I appear for the private response.
On the last occasion, my lord, I had submitted the talks of settlement were going on between the petitioner and the private respondent. My lord, that has materialized and the matter has been settled. I have instructions, my lord, to withdraw, my lord. My lord will kindly observe that the matter has been settled between the petitioner and the private
You
respondent.
don't want to proceed any further.
We do not want to proceed, my lord. No. My lord, my written instruction, my lord.
I just submitted on behalf of the petitioners. Learned counsel for the petitioners submits that the petitioners do not intend to proceed with the matter any further, since the dispute between the parties has been amicably settled. Paragraph in view of the above, the petition being is subject dismissed for non-prosecution. Urgency referred website.
Much appreciated.
Grateful, Lordship.
Twenty-nine.
My lord, in this matter, I beg to appear on behalf of the, my lord, the private.
My lord, I am appearing on behalf of the petitioner, led by Mr. Huda. My lord, I am praying for not to.
No, my lord, there is the direction for my lord filing the report. They, my lord, adjourn can be granted by lord, because of that, they led them to file the exceptional.
My lord,
My lord, the preliminary objection before your lordship is this writ petition is not maintainable. Because of that, the similar issue which has been issued in this connection of the plot in concern before the my lord Justice Shampa Sarkar, your lordship is directed to file a report annexing those documents.
So much of submission. He's
No,
not ready to
my lord,
pay.
my lord, that is maintainability point is, my lord, that is the,
It's already kept open.
my lord, that point. I am not praying for, my lord, they're objecting the prayer of.
I am appearing on behalf of the state, my lord. I am submitting affidavit in opposition, my lord.
Opposition was not called for. I
No,
will
no,
accept
no,
your
no,
affidavit.
no. My lord, may I hand it over
A
the,
report was called for, so please come back with a
It's
report.
a report in the form of affidavit, my lord. I am
Well,
submitting.
my lord, respondent number 8 and 9 is directed.
You are for 8 and 9.
8 and 9. I have been directed to file, not state has not. Then I can give another
It
chance.
said respondents, so it's all right. Let them come back.
My lord, just let them to sub copies, I can.
Petitioner, you are not ready today.
I'm for the led by Mr. Huda. My lord,
Receive the copies of the reports.
just I have received this.
And also serve the my learned friends, my lord.
In the form of affidavit reports, in the form of affidavit submitted on behalf of the state respondents, and respondent numbers 8 and 9 are taken on record. Paragraph on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 14th September.
My lord, in the meantime, my lord, these are serve the copy, my lord, the report which has been filed by the state.
Please serve a copy to the private.
And my submission, my lord, I have already served, that has to be recorded.
My lord, 4th September, my lord.
14th
September.
my lord, copy.
Report has to be filed.
আমি দিয়েছি তো
আমাকে কোনো কপি দেননি।
কপিটা করে দিয়ে দেবেন আপনি।
এই যে সই করা রয়েছে
নেক্সট
না, না, ঠিক আছে, আমি দেখি।
My lord, I am appearing for the petitioner. My lord, I am led by Mr. Arif Ali. I am praying for only not today, my lord.
My lord, for the respondent KMDA.
The earlier occasion also you prayed for an adjournment. Please be ready on the next occasion.
My lord, one
Only
can
not-
is pending on the similar issue before Honorable Justice Harish Tandon, my lord. And this, they have applied.
Division bench.
And in the single bench, on the similar issue.
Can is pending.
CPAN, contempt application.
Against which order?
Against the similar issue in another rate, previous rate. For that reason, the matter was adjourned on the last occasion.
Adjourned. It's being adjourned. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 18th September. I hope it will be considered in the meantime.
And they are supposed to do this.
Now.
31.
Yes, anyone? 31, anyone? None appears for the petitioner, no accommodation is sought, dismissed for default.
Hello, this is my application.
Yes.
যেগুলো ওখানে নেই।
My lord, I'm the petitioner, my lord.
My lord, I am opposing on behalf of the private respondent.
2 and 3.
2 and 3.
Who is appearing for 4?
For 4, my lord, I am appealing. 4.
2 and 3?
2 and 3, my lord. Okay, Mr.
2 and 3.
Oh, Mr. Aniruddha Chatterjee.
Mr.
Well,
Dev
Miss-
Chaudhary.
Mr. Aniruddha Chatterjee was appearing
Yes.
at one point of
He
time.
was
He had
appearing, very
attended
happy
it.
at my lord once or twice.
Mr. Devrup Chaudhary. I don't know.
Oh.
Mr. Chatterjee has been appearing all through.
Yes, madam.
Yes,
Mr.
yes.
Chatterjee had been appearing earlier.
Where is he? Chatterjee, Mr. Shoptorshi Kumar Mal.
Mr. Chatterjee's junior,
Possibly appearing on behalf of the
Urban Land Ceiling Authority.
That is 2 and 3.
That is 2 and 3, my lord.
4, my lord, I am
My lord, 2
present.
is the appellate authority and 3 is the competent authority.
Okay.
Or I can start, my lord.
In his absence, will it be all right?
My lord,
He has been appearing all throughout.
my lord, we've been wanting to move this application for quite some time, my lord. We're absolutely ready, my lord.
We're taking adjournment for quite some time.
No, no, my lord. My lord, we have not taken adjournment in this matter. আমরা adjournment নিই। না, না, adjournment নিই।
আমরা নিয়েছি, সবাই নিয়েছি।
আমরা নিই।
Will you come back next week? Will you inform him in the meantime? I'll fix a date.
Should the
Yes.
pendency of the writ petition will not be an impediment for us to.
I do not find his details.
অফিসার তো এতগুলো জুনিয়র আছে।
He could have started as one of his juniors would have been.
I agree, my lord. I can't dispute that. I think the respondent number 1 can inform, respondent number 4 can inform.
Petitioner has informed.
Has informed.
Has.
Someone has informed him apparently.
Hey,
I don't know, my lord. I can't.
My lord,
but I'm not
wait,
taking any responsibility.
Next week or next week.
Radio.
You had a whole lot of order, no?
None appears for respondent numbers 2 and 3.
None appears also.
No, no, no.
Paragraph
I mean, none
number
appears.
nine
You will
appear
speak.
under the same heading. On Monday 28th,
Sir, 28.
28th, Monday.
Monday.
Please inform Mr. Judge.
I will inform him, my lord.
August. Next.
Today, my lord, for everybody else is there, my lord.
28.
Pray.
28th Monday.
Yes, petitioner.
I'm for the respondent.
For the-
My lord, I beg to appear for the writ petition, my lord. My lord, another writ petition is pending. My lord, that has to be tagged along with this in respect of this same issue.
WPA.
My lord, WPA number 2389 of 2022.
Is it appearing in the list?
No.
Let there be another date.
Yes, yes,
62 Act,
62 Act.
but no private respondent.
No, no. All state respondents.
It is submitted on behalf of the petitioner that another writ petition pertaining to a similar issue as in the base petition is pending and needs to be taken up together for consideration. Paragraph in view of the above. WPA,
WPA 2389 of 2022.
let WPA 2389 of 2022 appear along with this writ petition under the same heading on 13th September.
Mal.
Yes. 34.
But I appear on behalf of the petitioner.
Respondents?
We've already informed and on the earlier occasion, he has given time in this ground, on his ground.
You're
First,
appearing for?
petitioner, along with sir.
Milord,
Mr. Bari was appearing for the state.
yes, yes.
Yes. So why don't you continue, madam? Yes, shall we start? Private respondents served.
Private, yes. Milord,
Proceedings, GHOSH.
Yes, all
Shinji
respondents.
Kodrahochi. Milord, I am being instructed that
Sir,
all of it.
still, the state is not there.
I cannot,
Passover not possible in this.
this is not done in this court.
This is the third time they are taking time. Rashid.
Will you come back on a short date? I'll fix up a short.
Milord,
I'll fix up a short date. Will you
you kindly fix up a short date why I am submitting, because it will not take more than 5 minutes.
1st September?
I leave it to my lords. I cannot make any say.
None appears for the respondents. Paragraph, let the matter appear under the same heading on 1st September. Please be ready on the next occasion.
Yes,
madam. I
yes.
read the matter even in your absence of the next day.
স্যার কিন্তু আপনার কাছে থাকুক কারণ এটা record of হ্যাঁ।
Next.
I'm grateful.
35.
Victory upon behalf of the state respondent.
I'm a petitioner. Yes. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 14th September.
Instead of 14, my lord, 15th or any other day.
15. 15.
15. Time is sure.
36. On behalf of?
For the petitioner in this matter. My lord, so far the matter is concerned, my lord,
State.
state served.
Mr. Day and Mr. Bari.
Then my lord kindly takes it up tomorrow in their presence. Because I believe in the earlier matter.
Mr. Jawaharlal Day.
No, he's
Jawaharlal Day.
no more in the panel.
No more in the
Mr. Bari is there. Mr. Bari is there. So my lord, possibly it will not be proper to.
Mr. Bari did not appear in an earlier matter.
So my lord, I'm serving notice tomorrow. My lord, kindly takes it up tomorrow. Then.
Back on first.
First, very well. My lord, the affidavit of service be kept on record. Oh yes, yes. I'm sorry.
1st September.
1st September.
Affidavit of
Oh, he has not come, right?
Affidavit of service submitted on behalf of the petitioners is taken on record. Paragraph, none appears for the state respondents. Paragraph, let the matter appear on.
My lord, may I just request one thing in the meantime? Let the BDA, the main authority is BDA. Let them come with a report in that effect.
We have got no power. Power under 4C minor. They have wanted to.
No.
Change the classification of land. We have got.
Wait a minute. My lord, that is under the Country and Town Planning Act, 1979. They had rejected. Yes, may I just appraise your lord? May I just appraise?
Yes.
But no, my lord.
Conversion can be.
Kindly take page 80. They has rejected page 80. Page 80 for once.
Yes.
Page 84 once.
Conversion is done by the BNL.
Well, kindly take, this is under the Country and Town Planning Act. Because BDA is a specific authority under this act, they govern this. Well, kindly see the act amendment. 31st of March 2023, non-issuance of development permission for residential use in RS plot number such and such. This is under challenge. With reference to your application number such and such, this is to inform you that the present and the development permission in the above mentioned plot for residential use cannot be accorded in your favor from this end. The reason for non-issuance of development permission is zoning conflict with LUDCP and BDA. As per LUDCP or BDA, the plot is situated in public and semi-public zone. This is under challenge. So I
Dealt with on,
yes,
you have dealt with the application on merits.
yes. So let them come with a report. But they have rejected.
How did you deal with this? You have rejected it on merits. How do you say that you have no power? Come back with a report, please.
Yes.
Yes.
Time. I leave it to your lordship. I leave it to your lordship.
None appears for the state respondents. Upon learned counsel for respondent numbers 5 and 6.
5 and 6, madam.
Seeks to submit a report in the form of affidavit. In this report in the form of affidavit. In this matter. Report in the form of an affidavit.
Yes.
In this matter, paragraph let the matter appear under the same heading on 14 September. Sufficient. Please serve an advance.
Advance copy, ma'am. Well, only one thing I need to bring to your lordship's attention that the other inhabitants, they have been given permission. Just surrounding my plot, everybody has been given
You have
permission.
annexed that.
Yes, yes, the photos and everything I have annexed, madam. Grateful.
The permissions you have annexed.
Lordship?
The permissions you have annexed.
No, the buildings are all there. It is all residential buildings are there. Surrounding, leaving my plot, Now, my lord, what they have taken, they said this is a country planning and town planning. Now, what is the planning? Leaving my plot, all other buildings have been given sanction and they have raised their building. Only I have been left. Yes, I'm grateful to your lordship. Affidavit of service be kept on. I'm grateful.
37, my lord. There was direction to file report with a clarification that on number of occasions, since it was not filed, your lordship will proceed even without report being filed. Now, my lord, after
No, my lord, I
this,
am appearing on behalf of the state. My lord, on 18th of, my lord, there isn't, my lord, kindly sees this.
On
My lord, inspection was held on 7th of August 2023 in the presence of the writ petitioner, my lord, and the department is, my lord, considering the process of handing over possession. My lord, kindly sees this. This is the communication made to me. Petitioners were present.
Yes,
Their
yes.
representative were present at the time of demarcation of plot and, my lord, the necessary steps. So I'll be seeking another month's time, my lord. Within this, the entire issue will be finalized. And this is also intimated to the writ petitioner.
my lord, may I just bring it? On 21st July 2023, they issued a notice that they will conduct a survey and hand over possession of the plot, which they are illegally retained for, my lord, number of 40 years. Now, my lord, in presence of my junior advocate and other representative of state, it was earmarked. The survey was conducted, all of them signed. They assured that in the meanwhile, we are in the process of issuing a certificate that it is being handed over to you. These are the two documents. Pursuant to that, they need to give a possession certificate recognizing that this is being given. This is one part. And second part,
Physical possession is with you.
physical possession, my lord, it was taken under Defense of India Act. The act was temporary. It, my lord, ceased. After it ceased, they retained it illegally. After we made representation, they said, yes, it will be handed over. Because there was inaction, I came in writ application. Now, during pendency, they said, this is the plot. We are going to give you a certificate that the land is being handed over to you. This, my lord, returns the property out of them. So far as the 30-40 years unlawful retention is concerned, since 1988, they paid me rent compensation. Since 88 till date, they need to give me rent compensation.
along with delivery of land. That apart, if there is any enhancement or other, that is to be decided by arbitrator.
My lord,
Been in possession.
Let them issue possession certificate and an affidavit.
Lordship kindly
This
fix
effect.
it on, subject to your lordship's my lord, convenience. Fix it on 27th of September, my lord. I hope that in the meantime, the possession certificate, my lord, 27th of,
As well as the rent compensation.
my lord, rent compensation, my lord, cannot be subject to
77
correction
rupees.
within this. So, my lord, my lord, whatever may be the necessary instruction regarding payment of compensation on that part, on that day, my lord, I will apprise your lordship.
These rupees.
So, my lord, let the possession or
Rajesh.
whatever may be handed over within this period. Lordship may kindly fix it. Lordship kindly keep this on record. May kindly fix it on 27th of
They
September.
will provide.
Subject to, my
possession
lord, your
certificate
lordship's
and file an
convenience.
affidavit.
Lordship kindly not say that. Lordship is kindly record this in
It
my
should
lord.
flag,
My lord, my lord.
I need something so that
My lord.
these two acts your lordship may record and they will issue some document recognizing that.
Learned counsel for the respondents. Cases
Rent compensation টা 77 টাকা per year
issued by the
88 পর্যন্ত
তুমি
দিয়েছে।
ইয়ে পাবেন।
first land acquisition collector, Kolkata, on 18th August 2023,
Actually,
which demonstrates that upon a joint field survey of the plot in question held on 7th August 2023, the plot was identified and found vacant. Stop learned counsel seeks accommodation so that the authority is able to take necessary steps
My
for delivery of possession of the plot in favor of the petitioners. Paragraph learned counsel for the petitioners submits that an assurance has been given by the authority for issuance of a formal certificate of possession in favor of the petitioners to indicate that possession of the plot has been, plot is being handed over in favor of the petitioners. Stop. The petitioners seek a direction upon the authority to pay rent compensation
Since 1988,
since 1988
when they stopped.
till delivery of possession in
Grateful
favor
to
of the
you.
petitioners. Paragraph, let the matter appear under the same head, paragraph by consent of the parties. Let the matter appear under the same heading on 27th September.
My lord, subject to your lordship's
As your
convenience.
lordship.
27th September.
Grateful.
That's great.
Grateful. আমার একটা কেসে এত কম্পেনসেশন হয়েছে তোমার খবর আছে। আমি ছিলাম স্টেশনে।
38.
My lord, I appear for the petitioner, my lord. Pursuant to your lordship's order, my lord, respondents has filed, my lord, report in respect of the land, my lord. I have also, my lord, used the exception to that report, my lord. Kindly seize the exception to the report, my lord. My lord, I am led by Mr. Pakrasi.
Who is Mr. Day for the respondents?
Yes. My lord, their claim, my lord, what happened, my lord? They are claiming that it was acquired. But we have shown, my lord, that all along, up to, my lord, 40 years, record has been, my lord, my name has been, my lord, recorded. Or my predecessor in interest name has been, my lord, recorded. Even RS, LR, even, my lord, in the midst of, my lord, the proceeding under West Bengal Highways Act, my lord, 1964, what they did, my lord, proceeding was initiated in June of 2021. They, my lord, get the record corrected in the month of my lord, July 2021. Thereby they are claiming that it was acquired, my lord. My lord, so I have used the exception, my lord, kindly seize the exception. I have, my lord, in this exception, all the statements have been, my lord, dealt with. What happened? They never, my lord, paid the compensation. That was your lordship's query, whether compensation was paid or not, my lord. I have shown that no money has been paid for the alleged acquisition. That was my lord, the categorical, my lord. Or
The 10-3 order has been passed against you.
yes, my lord. 10-3 order was passed. We preferred appeal. That was also rejected without discussing the fact, without my lord saying why that my land will be, my lord, treated as, my lord, vested land. My lord, in the midst of proceeding, my lord, that was, my lord, mutated in the name of state, my lord. That cannot be. If the, my lord, proceeding is to be initiated after observing that it is the land of the highway, till the date of proceeding, initiation of proceeding, it was in my name, my lord, in the record, LR record rights. That is admitted position. In spite of their claiming that it was vested, it was, my lord, compensation money has been paid. That is not also correct. I have, my lord, stated this in my exception. And they could not show that the money was received by the owner, concerned owner, my lord. My lord, kindly sees the exception. And that about, my lord, for your lordship's convenience, my lord, there was only one plot, 237. They are showing 237 by 1, 237 by 2. There is no existence of such plots, my lord. In spite and without producing document, they are claiming this. Only to avoid to pay, my lord, higher rate of compensation. They have done this. Even they, my lord, allowed conversation of the land, Vastu, from Danga. We have constructed 4-story building thereon. We are possessing this. And my lord, West Bengal Land Acquisition and Acquisition Act seized from 1997. Thereafter, they did not issue, my lord, fresh notice under 3A, in spite of their claiming that it was acquired, my lord. To continue with the, my lord, acquisition, they were required to, my lord, serve such notice upon the, my lord, owner of the land. My lord, it will take time, my lord. Probably it will not be completed today, my lord. Kindly see. Today is just, my lord, 9:01, my lord. So it will require, my lord.
What are the documents submitted by?
They
the-
did not annex any document, my lord. So far, the payment of compensation.
Let us hear the state what Mr.
Yes, my lord.
This is, my lord, entirely that is 10-4. After 10-4, my lord, they raise this point. That is when 10-4 is. My lord, that is the.
And they demolished my house, my lord. They did not wait for that.
My lord, if you lordship will come at page 4, my lord. That in connection with the subject mentioned above to the time notes that the work has been started. In for the purpose of physical implementation of health demarcation program, together with the help of the respective DLRO. Once is Kishanto Das, my lord, 14th Das. In the High Court hearing WP number of the state of West Bengal and others, court number Ato and Ato, the corresponding to Ato. From the record, has collected from department proceedings, found that the portion number Ato, and the Ato records out of Ato has been acquired for the purpose of construction of the approach road of Soivati Bridge of Bhatal under Ato, details smaller Ato. At the records, reveal that the budget of Ato and such request package of the plans was under the construction wing of Ato. The ownership details is plot number of the time acquisition as per record stated above. At the scrutiny that the name respective landowners exists in the awardee list of the Ato and Ato only signed by the Ato. Well, there is no dispute. Everything is there, man.
Well, everything is.
Where are the documents of acquisition?
Yes.
Yes, madam.
Where are the documents of acquisition? You say the land was acquired, then the petitioner encroached.
Yes, madam. That is I have stated in the
Document of acquisition, payment of compensation. It's a process.
everything is, my lord, in 10-4 proceeding, my lord, we never, if that is for the cause of the acquisition of the land, my lord, he prayed for compensation, other things are, my lord, then that is the challenge of that. But now this is a case of a, that is, my lord, they are.
The record of rights were corrected during proceeding, pendency of the
Yes,
proceeding under
yes.
section 10,
Yes, madam.
not before that.
So they cannot claim.
When it
बुझे
was
नहीं चाहिए।
detected that the record was not according to the provision of
Yes, so
the.
where are
Act.
the, will you please come back with the documents of acquisition?
Yes, my lord, everything is there, so I must come.
Acquisition documents are not there.
My lord, only statement is there. And award is, what the award is, that is the award is now. That is the award is name, my lord.
The petitioners deny acquisition.
That is, you can deny. As because, my lord, I can.
All right.
Give the report to that.
And also exception to that, my lord, we may be given time
Yes, yes.
after prior service of that my lord,
Exception
report.
used by the petitioner to the instructions submitted on behalf of the state respondents is taken on record. Paragraph learned counsel for the state respondents seeks to submit a report in the form of affidavit annexing relevant documents with regard to acquisition of the plot in question and connected documents thereto. Paragraph, let the matter appear at the same heading on 14th September.
14th September. Deeply obliged.
14th September.
What is the form of it?
In, yes.
Directed to supply the report. My lord, today we have filed exception that may be recorded. Yes, yes. Deeply obliged. 14th September. 14th September.
39.
Exception to file.
In 39 and 40, those two are analogous matter. That's why I am filing. Yes. Lordship, in the article number 39 and 40, those two are analogous matter. Yes. Lordship, today I am filing, Lordship, our exception. Exception to the reports filed by the general manager.
That may be deferred to some other department.
15. Yeah, again matter to 15.
38. 15.
You are the petitioner, Lordship. In two matters, Lordship, I am filing by the exception to the reports filed by the. Yes, copy? Yes,
Got it.
yes. Already, sir. So it's ready for hearing now.
Lordship.
Yes, Lordship. May I start, Lordship?
Yes, Lordship, we can start. Lordship, I will make a small preliminary.
115.
Oh, acha. Yes.
Exception used by the petitioners.
Lordship, only my request is except 11 to 18th September. I will be out of country for academic reason.
Exception to the report. Exception submitted on behalf of the petitioners to the report filed by the fifth respondent is taken on record. Paragraph, let the matter appear under the same heading. 20th? 20th. 20th September.
Obliged.
Yes?
Under heading
No, 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 no. Reports. Yes, yes. Let it remain at the same position, Lordship. I am grateful.
Obliged.
39 is with 40.
Yes.
Analogously. Lordship, analogous matter.
Sheet.
160 assigned matter.
Oh, sorry. Great. আমি এক নম্বর ম্যাটার সরি
আগে পিছিয়ে না তাড়াতাড়ি এখানে বস। রান করছে আজকে প্রথমে None appears. Paragraph, let the matter appear under the same heading. On 28th August, সোমবার। 161. Same order. 162. Same order. 163.
I beg to appear, Millet, on behalf.
Ma'am, for the respondent number 5.
টপটাও লিখে দিয়েছে রে
সেটা আমার তো
আমরা টপ লিখেছি ওকে
গ্রিপটা মোটা আমাদেরটা পাতলা
এই নামটা দিয়ে দাও।
এই তো বুঝতে পারছি
এখানে বলছো এখন
Before my lord looks to the brief, I just give a bird's eye view of the matter. This is with regard to installation of mobile phone tower. This is in the district of Howrah. Oh, I'm sorry, South 24 Parganas. Initially, before a guideline, was introduced in 2020, the municipalities in their own capacities, used to charge, a lump sum amount for, installation of towers. Some municipality used to charge, 3 lakhs rupees, some, even more than that. So, there was a disparity. In 2020, the state government, introduced an uniform guideline. Thereby introducing a single window clearance system. That is what the scheme is called. The purpose of the scheme was that there will be a single window, online window. I have to submit an application online with requisite documents and requisite fees, and I will get a permission provided I am found eligible to have the permission. The guideline also provided for regularization of those towers which have already been installed but not yet regularized, municipality not yet paid. The guideline provided for that also. I applied. Initially, there was a delay in giving NOC. Later on that was given. A few round of litigation took place in the meantime. In the second round of litigation, there was an order passed, granting me liberty, to apply afresh. I had already applied and NOC was awaited. After this order being passed, I got an NOC, from, in pursuant to the first application. But, by that time, I applied for the second time. I got a second NOC also. Despite that, the state authorities, particularly the district magistrate.
NOC is issued by the state.
Yes, the authority. There is a designated authority under the guidelines. There is a 3-tier system. The district level committee, then the state level committee, then the state level appellate authority. I'll take your lordship to the relevant portions of the guidelines. The district level authority is the authority to grant NOC. There is also a provision for deemed approval if the NOC is not given within a particular period. There are also provisions for putting in objections and for consideration of objections. Everything was done and NOC was issued. What is most important to take note of is this. The district magistrate himself is a part of the district level committee under the guidelines. Not only a part, he is the head. But the decision whether or not to grant NOC is given, the discretion is, the power is given to the authority, the body, not to individual wisdom. After this, since there was a previous order passed by Honorable Coordinate Bench, district magistrate, after this NOC and all, heard us. And my lord, by passing the impugned order, which is today impugned before your lordship, my lord, the district magistrate in his individual capacity, my lord, has revoked, my lord, those no objection certificates. My lord, that order is under challenge before your lordship. And my lord, the order proceeds absolutely on a wrong premise, and my lord, absolutely without jurisdiction, because the district magistrate does not have, my lord, any authority to pass this kind of order to revoke license. Kindly, my lord, have a look at the impugned order first at page 283. My lord, this is a two-page order. My lord, will kindly permit me, my lord, to place the order, my lord, from the very beginning till end. My lord, has kindly, my lord, arrived at page 283. My lord, this is an order passed on 6th of June 2023, which is, my lord, the subject matter of challenge. Notices have been served. Service written is filed for record. Petitioners and respondents are present. My lord, they are described so because of, my lord, their descriptions in the earlier round of litigation. Petitioners and respondents are present and filed hazira. Representative of ATC Telecom, my lord, me, infrastructure, etc., submitted that they had applied for permission for installation of mobile tower as per the guideline of 2020, issued by the Department of Information Technology, etc., dated 28th December 2020, should have been December. ATC Telecom Infrastructure Private Limited submitted an NOC reference number. My lord, will kindly take note of the reference number, the last 3 digits, 228. And another NOC, my lord, ending with 184. These are, my lord, the 2 NOCs, my lord, I was referring to. Records available in the single window clearance system portal. My lord, they have called this, my lord, they call this Onumoti portal. My lord, the single window portal. Records available in the portal of the department regarding the NOC with reference number 228 were perused. After perusal of the records, it appears that, my lord, these are the reasons. Objections had been raised in the portal at the district level against the application on 30th September 2021. My lord, will just take note that, my lord, this was, my lord, an undisclosed objection. My lord, I was never given any opportunity to deal with the objection. And my lord, in any case, this objection was with regard to the first application, first NOC, nothing to do with the second NOC. Objection had again been raised in the portal from the appellate level, the second tier state level, on 12th November 2021, again, my lord, pertained to the first application, first NOC. NOC was issued in the portal from appellate level on 24th May 2022. After perusal of the records available in the portal, it is not clear as to how the NOC had been issued, though the objections raised at district level and the appellate level have not been complied. My lord, this is, my lord, I will demonstrate, my lord, contrary to records, belied by records. My lord, firstly, see, my lord, who is, my lord, feigning ignorance? The district magistrate, who himself is a part of the authority, head of the, my lord, district level authority. He is saying he doesn't know how, my lord, the objections were dealt with. Also, as per point 7A Roman 5 of the guidelines of 2020 issued by the Department of Information Technology, in case, my lord, is quoted, in case the applicant fails to comply with the stipulated period of 15 days, the application will be considered as void. My lord, the question of complying with any requirement arises only when, my lord, I am made aware of the objections. My lord, there is a specific provision in the guideline. I will take your lordship to that. My lord, this never surfaced, my lord, these objections. I was never given an opportunity, my lord, to deal with this. So, my lord, question of compliance does not arise. Then, my lord, another NOC, my lord, all this were, my lord, pertain to the first NOC. Another NOC, number 184, was also submitted by ATC, details of which were submitted through written submission. The application is not shown in the portal at the district end. However, it is being shown at the end of the department. Kindly, my lord, mark this. So, my lord, DM is saying this is not available in his own portal, but it is available in the state's portal. My lord, if there is any technical glitch, my lord, I cannot be held responsible for that. As per clause 4B of the West Bengal, etc. guidelines, district level committee will facilitate and supervise permission to grant or allow or reject application seeking permission subject to certain conditions to set up the telecom infrastructure in the district. The district level committee will be solely responsible for granting NOC and shall keep the state level and state level appellate authority abreast of regular developments. But in this case, the district level committee could not scrutinize the application as it was not being shown in the portal. My lord, the NOC was granted by them only. Then kindly, my lord, turn over the page. After further perusal of the records at the end of the department and after considering written submission made by ATC, it appears that NOC was issued from the appellate level. As per clause 6A of the guidelines issued by department, etc., application is to be made in form 1 along with necessary documents in single window clearance system. After perusal of the documents submitted, it is clear that ATC has not submitted all the documents as mentioned in point E. Then, my lord, what is mentioned in point E is given, acknowledgement receipt, etc. So, my lord, the next allegation is that, my lord, one document was missed out. My lord, there is a provision, my lord, in the guidelines. I will show your lordship that, my lord, if any document is inadvertently or otherwise, my lord, missed out, not submitted, my lord, they have a duty to call upon me, my lord, to submit the document and to cure the defect. That never happened. And that is also not, my lord, stated in the, my lord, impugned order that, my lord, I was called upon. Thus, considering the above stated facts, it appears that NOC number 228, the first NOC, has not been issued as per guideline. The other NOC also does not conform to the guideline. Thus, the earlier order dated 23rd March 2022, my lord, this was first rejection by DM, first revocation, which was under challenge, my lord, in WPA number 6556. That stands. Appropriate authority as per West Bengal Telecom is hereby being requested to withdraw the NOCs. My lord, what is interesting to note is this. My lord, when the first order was passed in the first round of litigation by the Honorable Coordinate Bench, and my lord, then the second NOC was yet to be born. So, my lord, he cannot say, because of this, my lord, the first order stands and the second NOC also goes. First order passed by DM had nothing to do with the second NOC because, my lord, challenging the first order of revocation, my lord, this WPA number 6556 was filed. There, my lord, an order was passed giving me liberty to apply afresh. And, my lord, I applied and, my lord, got the second NOC. So, my lord, he cannot fall back upon the previous order to say that because of this, my lord, the second NOC also goes. Now, my lord, will kindly have a look at, my lord, the guidelines. Kindly take, my lord, page 245. I'm sorry, my lord. Kindly, my lord, have a look at the date.
And order was passed by the competent authority pursuant to an order passed by the school earlier proceeding. Now, my lord, the state order is now challenged before your lordship. Now, my lord, state order is now challenged before your lordship. Now, my lord, the entire order is, my lord, lordship, it's my lord, the longish order and the reason order. He can challenge it. He has every right, my lord, that pointing out the, my lord, the anything if it is contrary to law or guideline or illegality or even, my lord, non-compliance of natural justice. He can challenge it. Now, the question is, my lord, at the threshold today at the motion stage, when there is no scope for any interim order, if any order is passed, then the, my lord, the entire petition is disposed of. If your lordship be kind enough, my lord, to grant me, my lord, or so far I state is concerned, representing the DM and other, at least, my lord, 2 or 3 weeks time to file an affidavit against this petition, so that my lord can hear out the entire writ petition on the next adjourned date. Because today, if your lordship must subject to my lord's approval.
My lord, I will take only, my lord, 15 minutes of your lordship's precious time to demonstrate that, my lord, this order cannot survive even for a second. My lord, whether or not, my lord is taking a motion today. My lord, I will not be relying upon any document of mine. My lord, I will just rely upon the guidelines and nothing else. My lord, this can be, my lord, thrashed out, has to be. My lord, kindly appreciate my difficulty while, my lord, I am, my lord, asking for, my lord, an interim protection or, my lord, a final order, my lord, today. My lord, there is a mobile tower installed to cater to the needs of, my lord, thousands of, my lord, local, my lord, citizens. My lord, this is stopped. Electricity has been disconnected because of the order passed by the district magistrate. My lord, I have...
No, because of the order passed by the honorable court in the writ petition.
No, no. My lord, I will show, my lord, I humbly, my lord, join issue there. Milord, I will show that Milord, the DM, Milord, has completely exceeded his jurisdiction. Milord, DM is not the Milord authority, Milord, to revoke license. Milord, it's Milord for the state level committee, Milord, to do so. DM, Milord, out
That
of
order has not been challenged.
Milord, may I, Milord, without any interruption, make my submissions for 5 minutes? Milord, firstly, this order is absolutely without jurisdiction and that therefore, Milord, is a nullity. Now, Milord, because of this order, Milord, which is now today impugned before your lordship, Milord, I am, Milord, slapped upon several notices, Milord, by, Milord, the municipality and also, Milord, by the electricity authorities. Milord, the municipality has threatened me, Milord, with an immediate order of, Milord, dismantling, Milord, the tower. Milord, if today my learned senior friend gets, Milord, 2 weeks time, Milord, to put in his opposition, Milord, I otherwise would not be having any difficulty provided my tower exists. If today my tower is, Milord, dismantled, then, Milord, nothing will remain, Milord, to be adjudicated upon in the writ petition. Kindly, Milord, allow me, Milord, to put in, yes, because this has happened after filing of the writ petition. Milord, kindly allow me, Milord, to put in the supplementary affidavit. Milord, we are apprehending, Milord, this submission. Kindly, Milord, have a look at the annexes to the supplementary affidavit. Kindly have a look at the dates. Milord, this happened. Milord, the first annexure at page 4 is our communication of 6th of July from, Milord, the licensee. Milord, threatening, Milord, disconnection of supply of electricity. Then, Milord, the next communication comes, Milord, at page 6. Milord, this is more, Milord, fatal for me. This comes, Milord, from the municipality who is represented before your lordship today. And, Milord, they are contemplating to dismantle. Milord, if that happens, I have invested crores of rupees. And, Milord, in course of pendency of the writ petition, after, Milord, the writ petition is served, Milord, these kinds of notices are being issued. Milord, overreaching, Milord, the jurisdiction of your lordship. There, Milord, lies the urgency. Milord, I can come back after, Milord, 3 weeks or so, provided my tower, Milord, is retained.
Yes, Mr. Sen.
My lord,
Let the tower not be removed till the matter is.
Lordship, they have no sanction plan. I am for the municipality. Kindly direct them to produce the sanction plan in respect of the tower.
I'll immediately show that. Immediately show that.
Issued by the municipality.
Immediately show that.
So far, I am for the electricity company, respondent number 5. If your lordship kindly come to page 235, that is the order passed, but there are several, it appears there are several rounds of litigation. Now, if your lordship kindly come to the order, start from page 233 onwards.
Yes.
There was a specific direction upon the electricity company by this honorable court. Kindly come to page 230.
That is the specific
Fine.
direction of the district magistrate to pass.
That is the continuing running page 3 of that order.
And 235 is based on earlier order passed in the read court, that if the finding is such by the.
Milord, if my learned friends are getting into the merits of the case, kindly also allow me, Milord, to get into the merits of the case. Milord, all the respondents are vocal before, Milord, I could, Milord, show the guidelines.
The concerned station manager WPACDCL, who is responsible for supplying electricity to the petitioner tower, shall also ensure that electricity
Correct.
to the petitioner tower is disconnected.
Milord,
So
in
our part is
correct.
concerned, we have not
Absolutely,
disconnected.
Milord, which is why I am.
My learned firm is ad item on that. My learned firm will not dispute on that issue.
I'm not. That's why, Milord, I'm not asking for restoration as of now. Milord, the idea was if I, Milord, get, Milord, if I succeed before, Milord, the authority to have the NOC, Milord, this would be restored. Absolutely. But, Milord, if the tower is dismantled, everything goes.
So let there be no dismantling of the.
Yes.
Lordship,
It's taken
no,
up
no,
by the
Lordship, they, unless they produce the sanction plan of the
Then,
municipality.
Milord, kindly allow to.
No, the Lordship
The
kindly
town
see.
is-
No, no,
Yes.
Lordship kindly see page 233. They have failed to produce that.
Milord, I will immediately show it.
High Court Lordship.
I mean,
Lordship
immediately
kindly
show
see
it.
233, Lordship. The petitioner are aggrieved by an order dated 23rd March 2022. Lordship, that order was also passed by the same district judge, district magistrate, Lordship. Passed by the district magistrate, South 20 Parganas. In connection with memo number such as.
I've seen this order. They said
Lordship,
there was no.
expressly, Lordship, next paragraph. It appears from the order of the petitioner did not have no objection certificate or prior sanction,
Correct.
whatever, from the authority set up. Lordship, they have no sanction plan. If they produce that sanction plan, Lordship,
case of the petitioner, the
Exactly.
object, the NOCs were withdrawn subsequently.
No, no, no. They have no sanction plan. They have, municipality has not issued any no objection.
Standing as of.
No, no sanction, nothing.
I'm talking the tower, not the sanction. The tower is standing as on date.
It is.
Lordship, that is illegal.
That will be decided by the court.
No, Lordship, that has been already observed by the court, Lordship. Honorable High Court, Lordship.
They want to extort money, my lord. That is
Lordship,
why
kindly say 233, Lordship.
they want money.
I've seen
The
that.
prior sanction whatsoever from the authority set up the mobile tower.
That, sir.
Lordship.
Since you are, no, Mr. Sen wants to come back on affidavits.
Yes,
File
Lordship.
your affidavits.
Lordship.
In the meantime, do not dismantle the tower.
Right.
Still, the matter is because it's standing there, sir. They are not erecting the tower now.
Logical জিনিস হতে হবে।
Lordship, subject to they have produced the sanction plan with the municipality, Lordship kindly
Immediately
adjudicate or they, Lordship kindly take it up matter tomorrow, Lordship, they produce the sanction plan.
Will you be ready with your affidavit tomorrow? and
Ah,
solve the matter?
Yes, I'll be.
Lordship, only issue is that if they produce the sanction plan, the question of affidavit will stand. They, if they did not able to produce the sanction plan of municipality, they have raised the construction without any sanction plan. They have now came to court that we have invested huge amount of money which need to protect.
Reiteration of the submission will not make it
Madam,
stronger.
kindly record all these submissions.
Yes.
Lordship, they have no sanction plan, Lordship.
Madam, kindly give us at least 3 weeks.
Supplementary.
Solution
affidavit
plan.
service in the- Paragraph affidavit of service, supplementary affidavit submitted of affidavit of service and supplementary affidavit submitted on behalf of the petitioners are taken on record.
চলে যাবে। স্যার আমারও তো স্যার আমি নিজেই বিচারি আমি আবার কাছে চাই লেখাবো লিখতে গেলে কাকে দিয়ে লেখাবো সেটা
Third, learned counsels for the parties. Paragraph, learned counsel for the petitioners seeks an interim protection to the extent that it's a mobile tower.
Yes,
The mobile tower in question shall not be dismantled by the authority till the matter is adjudicated by this court. Paragraph, learned counsel for your respondent number.
Municipality কত নম্বর?
Respondent number 5. Rajput Sonapur municipality.
The fourth. Learned counsel for the fourth respondent submits that the mobile tower has been erected by the petitioners without any sanction plan.
And that has been recorded in the order, in the improved order of past.
By the
no, that's
order of the Honorable High Court.
এমনি ভুল হচ্ছে।
On 13th April 2022.
Coordinate court also finding.
তাও নয় সেটাও
233,
ভুল।
Lordship.
Over. WPA 6556 of 2022. Paragraph, learned counsel for the state respondents seeks to use affidavit in opposition in this matter.
I am for respondent number 5.
You also,
I am for respondent number 5.
yes, will you use an affidavit in
No,
opposition?
not-
Not required. It's your
Unnecessary, I will not.
We are not at daggers and will not.
party.
Also, in the event they produce the sanction plan, I have nothing to say. No,
They will produce, sir. They will produce. They have to. Otherwise, they'll not have the case.
Lordship.
So you don't need to come back with an affidavit. Only the state
Affidavit
has to.
বলবে যে ওদের
Yes.
ওদের এটা নেই।
Yes, Lordship, I will file it.
Learned counsel for the state respondents and the principal
দুটো আসবে তখন।
seek to come.
ওটাকে দেবে তো।
Counsels course. In opposition in this matter. Paragraph, affidavit in opposition, affidavits in opposition be filed within 3 weeks from date. Paragraph, affidavit in reply, comma, if any comma be filed within a week thereafter,
1 week.
within a week thereafter. Paragraph, let the matter go out of list for the time being, stop liberty to mention, paragraph. In the meantime, the fourth respondent, the respondents
Nice.
are restrained from dismantling the mobile tower in question. In the meantime,
Till further order, my lord will kindly clarify. my lord.
until further notice.
I'm so grateful. And would it be my,
Respondent number 5 here, in pursuance to the direction given by the Honorable High Court, has already disconnected that.
I mean, I have said so.
But it is not.
I have said so.
It's matter of the.
I have said so. My lord, would it be my lord's kind pleasure, my lord, to indicate a returnable date?
Immediately upon completion, mention.
My lord, it's really a challenge, my lord, for us, my lord, to come to your lordship, my lord, to travel, my lord, while mentioning. Because, my lord,
It's requiring physical strength now.
Lordship,
true, which, my lord, I do not
there
have.
there is a stay
So-
for dismantling the lordship. There is disconnection that kindly be recorded, otherwise they may,
Itself.
lordship, other, they may apply for the restoration of connection since there is an order and of stay, lordship.
Fresh connection.
Lordship,
Electricity
disconnection
room
that, lordship, kindly record there is still the disconnected, lordship, they are submit.
Come back after affidavits or consider the matter.
Kindly indicate a returnable date, my lord. Whatever date, my lord, suits your lordship.
Usually come back, I'll consider.
Provided, my lord, I get a chance. Grateful.
Though the
Grateful.
electricity is the consequential relief, in the meantime, not
It's already disconnected, not necessary at this moment.
Grateful, man. Grateful.
তাহলে স্যার আপনি সবই করবেন তাকে তোলা is your experience. তাকে
Next.
out of list for the test. আমি বলবো না তুমি বলবো
164.
মনে করে গেলে বলে দাও। So I am for the writ petition in this matter, my lord. Lordship, on previous occasion, that is on 26th of July 2023, my lord. The lordship has heard this matter extensively, and lordship was pleased to record my submissions.
Yes,
Yes. Now, my lord, this is a matter lordship will remember. Lordship, it's a contract which I have executed with the railways for the purpose of cleaning. And after commencing the work, my lord, all on a sudden they have terminated my contract. Now, lordship, that
Acceptance.
yes, sorry, it's a letter of acceptance, my lord. They have terminated the letter of acceptance and imposed me with punitive measures, which, as per the tender conditions and the general conditions of contract, can only be implemented if there is a proper contract in it. Now, on that score, my lord, I have relied upon some of the judgments, my lord, of the Honorable Apex Court and also of the coordinate bench. Now, my lord, please come at page 37 once, my lord. Kindly see the nature of punishment which has been imposed upon me.
Have you taken instructions in this matter?
Yes, my lord, your lordship on last.
Only one thing, my lord, before my learned friend starts, my lord, lordship will find that in the last paragraph, there is a punishment of blacklisting. Now, blacklisting, my lord, page 37. Lordship, page 37, last paragraph.
Yes.
In addition, your participation as well participants of every member partner in any manner as an individual or a partnership firm is hereby debarred from participation in the bid of executing any work being tendered by Chakradharpur Division, Southeastern Railway for a period of 2 years from the date of issue of this letter. My lord, this is a blacklisting, my lord. I have not been provided any opportunity to place my case, my lord, before this punishment has been imposed upon me. Now, there is a lordship, there are catena of judgments of the Honorable Apex Court and single bench also, my lord, where it has been stated. May I place that?
That is natural justice.
It's a natural, but blacklisting has a civil consequences, my lord. It debars me from entering into any lawful contract with the organization. And that too, lordship, has been imposed upon me without giving me an opportunity of being heard. And secondly, my lord, this termination notice, lordship, suffers from 4 contingencies, my lord. First, my lord, what I have stated right now. And second is the post-contractual punitive measures have been imposed. Because in the tender conditions also, in the report, which they have placed before your lordship, they have enclosed the tender conditions, from where it clearly reveals, my lord, the punitive measures which they have imposed upon me can only be done after there is a formal agreement executed. Now, that has not been done, my lord. And so far as the damages which has been imposed upon me, that is 1 crore 10 lakh, lordship will find that at first paragraph, 1 crore 11 lakhs, my lord. Lordship remembers that the entire contractual value is of 29 lakhs 83,147. Now, the rules, lordship, they have applied, neither they have come up with in breakup, no statements have been given, and nowhere it comes even near to 1 lakh. Now, they have imposed me 1 crore, that is above the 4 times the contractual amount. They are not permitted to do so.
Because Lordship will find the entire contractual value is 29,83,147. And the punitive and the damages has been imposed upon me is of 1,11,56,000, my lord. And even there is a no contract, my lord. That is also where I have relied upon authority, my lord, where it is said that there has to be a contract in existence for imposition of any damages under section 73 of the Indian Contract Act. That is, the Lordship was pleased to refer that also in that order. So, my lord, in this termination letter, Lordship needs to be dealt accordingly, my lord, because this is something which cannot sustain in the eyes of law.
On last occasion, your lordship was only query that whether the letter of acceptance is deemed to be account to be agreement or not.
Contract.
Yes, my lord. There is an offer and acceptance. Kindly come to the page 29. Letter of acceptance.
A letter of acceptance and a contract are not synonymous.
But all agreement or contract. Yeah. As per section 10 of Indian Contract Act, all agreement or contract where free consent has been given by the parties. And they has been submitted the document signed by the parties. When the document of the tender document has been filed before the department, before the authority, after when the letter of acceptance is given, PG has been given. My lord.
Page 29 is the.
Page 29 of the letter of acceptance. First paragraph, the competent authority has accepted your offer, rates and connected with the subject work. The total cost of the work, here is a acceptance of offer has been given. Free consent has been given. This document has been digitally signed by the Ganesh Prasad Singh, who is the competent authority.
Competent authority.
Dhiraj.
Competent authority.
Who is the power of attorney holder, or the one of the partner of the who has filed this writ petition, Dhiraj Kumar, and also he submitted the tender document. Every page he has been signed. Where in this letter of acceptance, kindly come to the last.
1, 2, 3.
Come to the
4,
last
5,
line, my lord.
Sixth line of your letter of acceptance, page 29.
Sixth line.
Yes. Within 30 days from the date of issue of letter of acceptance.
PG has been
Valid up to stipulated date of completion plus 60 days, so that contract agreement can be executed.
For the purpose of depositing the
contract agreement.
For the
purpose you issued this letter of acceptance.
Letter of acceptance was issued on 1/9/2021.
Sixth line of the letter of acceptance.
Valued up to stipulated date of completion plus 60 days.
After that, just after that.
So that the contract agreement can be executed.
Yes.
The PG should be in favor of.
Wanted to execute a contract agreement upon fulfillment of these terms.
Kindly come to the.
There is a contract agreement.
Kindly come to the last line of this letter.
Yes.
All other terms and conditions as stipulated in the tender document shall be applicable. That all other terms and conditions tender document, kindly come to my affidavit in our report, my lord. Report in affidavit.
Please come to the first line of page 30.
Yes, my lord. The decision of authority competent to sign the contract agreement would be final case of any dispute.
So where is
Kindly
the
come
contract
to that's why I will satisfy. Kindly come to my report. Come to my report. Tender document.
Please do not harp on the tender document. I am looking for the contract agreement.
Whether it is a contract or not, it is a agreement or it is on the basis of agreement. On the basis of, he has agreed. He has given free consent.
Signs in the
Kindly come to. He has submitted the form also. Bid form.
lines that I have pointed out in your letter of
On
acceptance
the,
first.
that only purpose of the depositing the PG means? Performance guarantee.
Not at all.
This is under the performance guarantee. Within 60 days, you have not been
Contract agreement. Where is that contract agreement?
contract agreement. This is the kindly come to the, it is unless a bid form, he has been given the signature, all the tender document has been signed by the, until formal agreement is prepared and executed, accepted of the page 50, my lord, of my report, my lord. 50, my lord.
Yes.
Thus, this document has been only format, that the signed document has been deposited, this is the signed document. Where the signature has been given, where is the Dheeraj Kumar? Signature টা তোমাকে এখানে দেয়নি।
তোমার রিপোর্ট তো এটা সিওর
আমার রিপোর্টে মানে আমার এটা ফর্ম
blank?
দেওয়া আছে। Page 50, bid form, last line. Until a formal agreement is prepared and executed, acceptance of this bid shall constitute a bidding contract between us, subject to modification as may be mutually agreed to between us and indicated in the letter of acceptance of my hour offer of this work and service. So he has accepted. He signed this document.
Where is the signature?
All the this document, this signed document has been given, my lord. Kindly keep. When the bid document has been submitted before the online, thus all signed document, these all document has been signed by the Dheeraj Kumar, who is the partner of the Ganesh Prasad Singh. He has agreed, he's given consent also. The all terms and condition of special terms and condition of the tender document, he has to be followed.
Where is the letter of acceptance? It is that 29 is the letter of acceptance.
29 is the letter of acceptance. In the 29 of letter, last paragraph has been all terms and condition has been followed. Then all terms and condition, what is the special terms and condition? GC 2018. And this is the bid document. He has signed this document. All the document he has been signed before and submitted online. Here he also given consent that until a formal agreement is prepared and executed, acceptance of this bid shall constitute a binding contract between us. This is the binding contract. On this basis of binding contract, we can apply the special terms and condition of the authority.
Whose mobile is this? Whose phone is this?
When he submitted that this all document has been signed and agreed with that authority and
accepted.
Yes.
Have you given an opportunity of hearing to the petition?
Yes, my lord, he has been, after that I given a notice to the, this is the note, kindly come to the notice. 25
Of your report?
25C in the writ petition annexure P2. Letter of acceptance was issued on 3/2021. Performance notice I have given as per terms of the special terms and 25/3/2020. What was the discrepancy? Page 33. Annexure P2.
Performance notice.
Performance notice. What discrepancies has been followed by examined by the authority of the department has been given detail of this 1, 2, 3, 4, 5, 6, 7. Every detail, what was the discrepancy has to be done by the Ganesh Prasad, what he has not done as per terms and condition 1A, annexure 3, 1.2, annexure 3, clause 3, 1.2. Nothing has been submitted. Thereafter, he also given 7 days notice before termination.
Please come to clause 7.3 and 7.4 of the general Conditions of contract act, contract,
7.4.
7.4. Page 34, the last paragraph.
In my report, madam.
No. Page 34 of the writ petition. You just now pointed out.
Yes, madam.
Notice in accordance with clause 7.4.
Yes. 3, clause 3.
Clause 3.
As you have been failed to abide by the instruction issued or comply the desirable standard of service, you are hereby given a notice in accordance with 7.4 general condition of contract to make good and default, failing which further action will be taken as provided in clause 7.4 of the general condition of contract
So
while
please come to
termination.
7.4 of the contract. The
7.4
conditions
general
of
terms and
contract.
condition is another.
It is annexed.
This is not annexed because this has been handed over to.
General conditions of contract, my lord, is applicable only after a contract is executed. Before that, it cannot be.
This says that this is
the contract.
May I say, ma'am, the honorable, even if, my lord, in the tender papers also, which my learned friend has annexed in the report, it clearly distinguishes the two situations when these punitive measures can be applied. Kindly see the report. In the tender condition, it has distinguished it. What?
It says that this can be termed as a contract.
No. Honorable Apex Court has clearly stated.
Yes.
7.5 is I have folded.
7.4.
7.4, my lord. Determination of contract owing to default of contractor. General terms and condition. Page 61, perhaps. We can inherit আলাদা একটা document. General terms and condition যেটা download করে বের করতে হয়েছে। না, general terms and condition এর বেসিসেই তো দিয়েছে। General terms and condition.
As you will find, the GCC is only applicable after the contract is executed, not prior to that.
A 7 days notice was also served.
7 days notice also served.
After that, there should be a termination.
Thereafter, termination notice has been given.
And there is no provision
7 days
for-
notice, 1/4/2020, 7 days notice was given. Termination notice was given.
And there is no provision for hearing the applicant before termination.
No, there is no provision because they have given reply to the 70, even he has not given the note, reply to the 7 days notice also.
They have given a reply.
They have not given.
A reply.
They also accepted, they have given, they made a fault in their letter, in the reply of 25/3/2020. This is the performance notice, 25/3/2022. He himself accepted that he has made a fault. Kindly come to the page. This is the translated copy, my lord. Page 36, my lord, 36A
Of the writ petition.
of the writ petition, my lord. This was, reply was given in Hindi. This has been translated. 36A.
Yes.
In compliance with the traders, whenever the deficit were there, so far the employees were concerned. This is the last line, kind of, this in this paragraph, last line. And I have also got the biometric to the order which shall be installed soon. They have not also made biometric. Thereafter, since I did not have the entire information, upon having got intimation through letter from your end, I have made rectification of the same at the earliest and make prayer to
you to submit eligible. And I fully believe that I shall make further rectification in the future also. I was doing the job on subcontract basis, which is not permissible as per 4.5 on the general.
That was not taken as a ground for termination. Lordship, kindly note that also.
Some mistake has been committed due to lack of information, which while I was not aware of before receipt of this letter. After receiving the information, I have got the performance of the worker to improve. Whatever is left, I shall get the same modification at the earliest. I shall pray to you kindly revoke the 7 days notice given to me. I want to further job regular manner. In kindly give me the permission to. He himself admitted his fault. He has made fault. What as per format 1, 2, 3, 4 was what has been submitted before the authority and signed by the authority, that also not been met. In the 25 March letter, I have given detail as per which terms and condition you are discriminating the tender document and tender terms and condition.
You come back on affidavits because there are several factual aspects.
Lordship, I will deal with this allegation, my lord. Well, kindly appreciate. Let him finish, my lord.
Last one thing. The termination notice. In the termination notice, he is told that he has been debarred from the Chakradharpur division, not
that
the
is also blacklisted.
Southeastern Railway.
That is blacklisted.
He has been participated except Chakradharpur division. He has not been blacklisted only for Chakradharpur, not the entire
If
Southeastern.
if his submission is considered, then the department in Chakradharpur is not a blacklisting, my lord. If my learned friend contention is to be taken into account.
That is what he says.
Now that is department is blacklisting.
Had submitted that you will not be able to participate in
Yes.
any tender.
In any tender, because I have my business in Chakradharpur division. If the Chakradharpur division is taken out from me, then I cannot take part in any tender out of the Chakradharpur division. It's a part of Southeastern Railway. Now, my lord, I want to say that what my letter of acceptance is not a letter of acceptance, it's a counter proposal. Lordship, kindly see what is there in it. Honorable Apex Court has clearly stated what can be treated as letter of acceptance and what can be treated as counter proposals.
You have not challenged the letter of acceptance, have you?
No, letter of acceptance containing counter proposals. These are the things which I require to do. Kindly see.
I also agree with
You are my lord.
not giving the required document also.
Lordship, kindly see the second paragraph. You are requested to submit performance guarantee in the form as given in the clause 4.1, equivalent to 3% of the contract value amounting to such and such within 30 days from the date of issuance of letter, valid up to the stipulated date of completion plus 60 days, so that contract agreement can be executed. So I have to do certain things. The PG should be in favor of FA and COA, Southeastern Railway, Garden Ridge, Kolkata 43, and same must be submitted at the office of senior DME within 30 days from the date of issue of the letter of acceptance, that is up to 39/2021. Extension of time for submission of PG beyond 30 days and up to the date of submission of PG from the date of issue of LOA may be given by the authority who is competent to sign the contract agreement. However, penal interest of 15% per annum shall be charged for the delay beyond 30 days, that is from 31st day after the date of issuance of LOA. In case the contractor fails to submit the requisite PG, even after 60 days from the date of issuance of LOA, that is up to 30/10/2021, and notice shall be served to the contractor to deposit PG immediately, however not exceeding 90 days from the date of issuance of LOA. In case the contractor fails to submit the requisite PG even after 90 days from the date of issuance of LOA, contract shall be terminated duly, forfeiting EMD and other dues, if any, payable against the contract. You will also be debarred from participating in any retender work, and in case 90th day is a bank holiday or office closure, next working day should be considered as the last day for submission of PGs. The decision of the authority competent to sign the contract agreement would be final in case of any dispute. The entire work shall be completed within 36 months from the date of issuance of letter of acceptance. The entire work will be completed within 36 months from the date of starting of the work, not from the date of issuance of LOA as mentioned in the previous statement. However, the work must be commenced within 30 days from the date of issuance of LOA as per the special terms and conditions and contract clause 1.21. Now, my lord, these are all the counter proposals. It has been dealt by the Honorable Apex Court. Lordship, I have already judgment. Lordship, kindly see paragraph 32 of 2006 volume 1 Supreme Court cases 751. Paragraph 32. Clear distinction has been made what can be letter of acceptance and what is the contract. Paragraph 32, my lord. 2006 volume 1 SCC.
Yes.
Cases 751. Lordship has found parties agreeing upon the terms subject to which contract will be governed when made is not the same as entering into the contract itself. Similarly, agreeing upon the terms which will govern a purchase when a purchase order is placed is not the same as placing a purchase order. A prelude to the contract should not be confused with the contract itself. The purpose of revision 4 dated 10/6/1991 was that if and when a purchase order was placed by vendor, that would be governed by the general conditions of purchase of vendor as modified by revision 4. But when no purchase order was placed, neither the general conditions of purchase nor the arbitration clause in the general conditions of purchase became effective or enforceable. Therefore, initiating the revision 4 by DR of Bindal on 10/6/1991 containing the modification to the general conditions of purchase did not bring into existence any arbitration agreement to settle the dispute between the parties. So it has been clearly stated that LOA, which my learned friend is saying is a contract, it cannot be because it contains counter proposals. It contains counter proposals. And now, my lord, from the tender documents which my learned friend has annexed, kindly see the demarcation is quite clear. Page 20 of their report. This is the tender conditions. Lordship, page 20. Lordship, kindly from the performance guarantee, my lord.
Yes.
Page 20, that is the from the middle portion, the performance guarantee. The performance guarantee shall be submitted by the bidder after the letter of acceptance has been issued, but before the contract agreement. These performance guarantees shall be initially valid up to the stipulated date of completion and maintenance period, if any, plus 60 days beyond that. In case the time for completion of service gets extended, the contractor shall get the validity of performance guarantee extended to cover such extended time for completion and the maintenance period, if any, of the service plus 60 days. Now, Lordship, we'll skip say 6 lines. Lordship, kindly come to whenever the contract is rescinded. Whenever the contract is rescinded, the performance guarantee shall be encashed and forfeited. Here, my lord, there is no contract. So they cannot forfeit my performance guarantee. The balance work of service for the same shall be got done independently without risk and cost of the failed contractor. The failed contractor shall be debarred for a period of 2 years from the date of such rescindment from participating in the bid, which includes delivery of balance services of failed contractor. If the failed contractor is a partnership firm, then every member partner of such firm shall be debarred for a period of 2 years from the date of such rescindment from participating in the bid, which includes delivery of balance service or failed contractor in his individual capacity. Well, these are all the punishments which contemplates there has to be a full-fledged written contract between the parties.
And the last paragraph of page 50.
Now, the last 2 lines of the same page, the contract being determined or rescinded under provision of the GCC, the performance guarantee shall be forfeited in full and shall be absolutely at the disposal of the president. Now, this can only be come into consideration, the punitive measures, after there is a proper contract. There has to be the procedures after which it can be terminated. The procedures cannot be implemented in pre-contractual situations, my lord.
The last paragraph of page 50 report.
Wait for me. Until a formal agreement is prepared and executed, acceptance of this bid. Lordship, this is not an acceptance. The letter of acceptance, which I have already read, my lord, I have placed before your lordship, does not, it's not a letter of acceptance. It contains counter proposals. These are the things which you have to do. So it cannot be a letter of acceptance. It cannot bind me. For binding, there has to be a formal contract. General conditions of contract, special conditions of contract, and standard conditions of contract can only be made applicable when there is a formal contract executed. This cannot bind me because it is not a letter of acceptance in its true senses. It contains counter proposals. And also, my lordship, kindly see page 6 of their report. It is stated, my lordship, page 6 of their report.
Yes.
Paragraph 17. It is stated that the penalty has been imposed to Mrs. Ganesh Prasad Singh following the terms of the general conditions of contract for service of 2018 and special conditions of contract of railways. So I am putting this question to myself, my lord, how that can be done? Because pre-contractual stage, nowhere, let my learned friend shows a single scrap of paper that these conditions can be made applicable in pre-contractual stage. Now, total penalty imposed for the period of 27/9/2021 to 13/3/2022 against a letter of acceptance is coming around 1,11,56,000. My lord, kindly see the rules which they have relied upon. These rules, even if it is computed, my lord, nowhere comes at least near to 1 lakh. Lord, you leave aside the 1,11,56,000. Now, no breakup statement was provided to me. And then paragraph 19, I state, lordship, next page, I state that the contract has been terminated as per clause 7.41 of the GCC service contract 2018 after obtaining approval from the contract authority. These provision cannot be applicable in my case. Nowhere they have, let my learned friend demonstrate a single line saying that these 7.41 can be made applicable in respect of pre-contractual stage. General conditions of contract only applicable, my lord, when a formal contract is executed between the parties. Yeah. Stipulating the conditions, the punitive measures. Letter of acceptance does not have the punitive measures contemplated therein.
Have you seen the Supreme Court's judgment?
My submission respect to submission before your lordship, I just.
And lordship, another aspect, so far as the debarment is, lordship has seen threefold punishments has been given. So far as the debarment is concerned, my lord, also, they have not given me an opportunity of hearing. There is a coordinate by judgment on this, my lord. I will be relying upon that also.
2017?
No, my lord, it's a unreported judgment. Lordship, I will not trouble your lordship with the entire order. Only lordship will kind enough to come at page 9, internal page 9. The paragraph 10, my lord has found.
Yes.
The impugned letter of termination, therefore falls foul of the contractual terms between the parties. The letter of termination is also in violation of petitioner's right to a fair hearing before the agreement was terminated and the petitioner's security deposit forfeited. Here, my lord, there is an agreement, but here there is no agreement. The action of debarring the petitioner from future tender is high-handed, arbitrary, and against the contractual terms executed between the parties. As recognized by the Supreme Court in MSS Eurasian Equipment and Chemicals Limited versus State of West Bengal, blacklisting has the effect of preventing a person from the privilege and advantage of entering into a lawful relationship with the government for the purpose of gains. Supreme Court was also of the view that the fundamentals of fair play require that the person concerned should be given an opportunity to represent his case before he is put on blacklist. The view was also echoed by the Supreme Court in Jagdish Mandal versus State of Odisha, such and such, where the Supreme Court held that the cases involving blacklisting or imposition of penal consequences on a contractor require a higher degree of fairness in action. For the reasons as stated above, this court finds that the impugned letter of termination dated 31st March 2021 liable to be revoked and set aside. WPS such and such is accordingly allowed and disposed of in terms of prayer A and B. Respondent Railways is restrained from giving any effect or further effect to the impugned letter of termination dated 31st March 2021. My lord, it's an established principle, my lord. I was not provided an opportunity. Neither I have contemplated that as because there was no punitive measures indicated in the letter of, as my learned friend is saying, it's a contract. So the punitive measures have to be there in the letter of acceptance so that I know that if I do something wrong, then I will be blacklisted. The question of blacklisting never came in my mind that I will be debarred from doing any business with the railways for 2 years. So they have done it. They have caused a civil wrong to me, and that too without giving me an opportunity, my lord. And secondly, when there is no contract, my lord, under section 73, I have already placed that judgment on previous occasion. It says, my lord, may I read once again, my lord, that how they have computed the damages. Lordship, AIR 2017 Supreme Court 2035. Lordship,
Yes, sir.
paragraph 13. Lordship has found, my lord. AIR 2017. Yes, Supreme Court 2038. Paragraph 13 says, my lord, as because they have imposed a damage of 1 crore 11 lakhs, that too without substantiating how they have computed it. Lordship, kindly see, section 7 of the Indian Contract Act provides that in order to convert a proposal into a contract, the acceptance must be absolute and unqualified. That there is no absolute, lordship, acceptance on my part, because LOA contains counter proposals. The existence of a concluded contract is a sine qua non in a claim for compensation for loss and damages under section 73 of the Act arising out of the breach of contract. If instead of acceptance of proposal, a counter proposal is made, no concluded contract comes into existence. So they have to at least show, my lord, that there is a conclusive contract in between me and him. Because the letter of acceptance, my lord, cannot be constituted as a contract because it does not contain all the features. It does not contain all the conditions, because an agreement, lordship, will find it have the several things which guides me. The letter of acceptance is silent on those regards. And also the tender documents is also very clear. It distinguishes the 2 stages. When one can be said to be a pre-contractual stage, when one can be said to be a post-contractual stage. Honorable Apex Court judgments are there, my lord. And I have not been provided an hearing, and blacklisting has been done behind my back.
That's all.
That's. And computation of amount is also arbitrary, my lord. They have failed to substantiate how they have come into in that. And there has a specific pleading there in my in the writ petition.
In 17, computation has been given in detail.
And I have also stated, but that was not accompanied with the letter of termination.
Will you deal with the judgments and come back? Because judgments do not support you.
As per my respectful submission is that the bid document, which has been as per section 10 of the Indian Contract, the bid document has been signed, given the free consent, offer and acceptance is there. Then he accepted that the all terms and conditions will until the formal agreement has been contracted. Why the formal agreement has not been executed? I have given several reminder that the such document has to be submitted. Required document has been submitted, just the GST number, PAN number, such and such thing. That has been annexed to my report. That has not been given. So until and unless formal agreement has not been executed, the tender, as per tender document, every document he has been given signature and given consent, written consent. This is the recent written consent. You will binding by the all terms and conditions.
The conditional document requiring the petitioner to
Is
submit.
binding by.
Yes.
Do you
Until unless.
do you want to come back after distinguishing the, because the Supreme Court doesn't say so. Supreme Court has distinguished between a letter of acceptance and a contract. So if you want to come back, because the court is of the prima facie view that it has to be sent back on remand.
Let it will come back.
Yes.
I will reply you next.
Please consider the judgments and come back.
Yes,
That
yes.
is what I
Actually, further, I always say, my learned friend cannot develop the case, my lord. Already he has placed every.
You can distinguish because the Supreme Court.
Because
against,
Lordship has given that opportunity to my learned friend. I will not stand in his way.
You are enjoying an interim order.
I am enjoying an interim order, but it's my lordship, I cannot place my bills because if I place my bills, they will deduct it. Instantly, they will deduct it because they have raised one crore.
Fairly short date.
A fairly short date, my lord.
Because it has been substantially heard.
No, affidavit opposition is not required, my lord, on the basis.
Affidavit, I'm not calling for affidavits.
Please, only.
You don't need to come back on affidavits, I think. Please consider the judgments, the documents submitted by the petitioner and come back.
Yes, yes.
Because prima facie, the Supreme Court holds otherwise. Otherwise, I would have passed an order today.
Okay,
I want to give an opportunity to
yes.
the respondents.
Well, lordship fixes date so that my learned friend can places those judgments.
Yes,
and
yes.
advance copy to me. Only upon that, lordship can.
Your lordship only queries that the distinguish the judgment of Supreme Court 2017.
Since the judgments are not really in your
Pre-contractual
favor.
or after. After.
That's why I want to give you an opportunity. Otherwise, I can make it. I can reserve the judgments and pass orders.
Lordship reserves it for CAV, my lord.
Yes.
Actually, till now I have no knowledge about that judgment. Also.
Have you seen the judgments?
I have seen, but on the contrary, I have not seen a search.
Then lordship reserves the judgment.
So I reserve this
Yes,
for
yes.
judgment.
Yes, lordship. Yes.
Yes.
Reserves it, my lord. Lordship grant extend the interim order, my lord, till disposal. Because it's expiring on 31st August.
Only respectful submission is that there has been given opportunity. Advocate letter also has been given.
There is the opportunity of hearing. When you fix a date, and you give an opportunity.
Opportunity of having physical hearing has not been given, but he has been given reply.
That also a coordinate bench has decided.
In
that
annexure,
also.
it also kindly also only one thing.
In
Advocate
fact, this
letter.
court doesn't have much to decide.
Advocate letter he has been given. That letter has a paragraph, para-wise statement, reply also given.
This letter state the date of hearing and give an opportunity.
No, that has not been given.
A coordinate bench
As
has
per,
decided
that has not been also, as per terms and condition has not been provided. Only some.
In fact, fortunately, this court doesn't have much to decide in the writ petition because it has been decided.
Yes.
As per special terms and condition, he has been given opportunity 7 days notice, thereafter termination. And before that, he has been given performance notice also.
Arguments concluded, judgment reserved.
Lordship interim order may be extended.
When is it expiring?
31st of August.
Paragraph, the interim order granted earlier is extended till delivery of judgment.
Great.
Is extended till delivery of judgment.
Lordship grateful Lordship has given a patient hearing, my lord.
Next.
165.
This matter relates to registration of e-rickshaw.
The lordship passed usual orders.
Yes, Mr. Sinha has to say. Usual.
My lord, may I kindly refer to the last order
Which last order?
of your lordship?
Yes.
My lord, affidavit in opposition has been taken on record. My lord, may I,
Without calling for.
my lord, may I take your lordship to page number 29
Of the writ petition.
of the affidavit in opposition?
Yes.
My lord. My lord, in this matter, my lord, with regard to the manufacturer who have done agreement with me, this order has been passed by this honorable court, my lord, who has signed agreement with me.
Please appeal
And
for the state.
my lord,
Yes,
and
your appeal.
I am led by Mr. Pontu Devla.
my lord. My lord, in this matter, my lord, they have signed a license agreement with me. And at the time of signing of the agreement, the both signatories were Mr. Inder Rajpal and Mr. Makhija. Presently also, when the nomenclature of the company changed, means at that point of time, that company is of proprietorship, I think. And now, if I'm not wrong, my lord, and now the company has changed its nomenclature. Only it has become private limited company, but both signatories were same, my lord. The purpose of business, everything is same. And my lord, in the agreement, also in the affidavit in opposition, my lord, may I take your lordship to page number 18 of my opposition.
Yes.
My lord, there is a revocation clause mentioned clearly.
Yes.
Any dispute, claims, or question is ruled out in case of any dispute arising out of deed or any dispute regarding the representation obligation, my lord, between the parties or construction, interpretation, or application thereof, any clause or thing herein contained, or as any act, deed, or commission, omission of any person, or as to any other matter in way relating to the deed shall be referred to a sole arbitrator, my lord. My lord, these were clear-cut terms signed by and between the writ petitioner and me. My lord, thereafter, they have changed the nomenclature of the companies. Signatories were same, purpose of business were same, and they have filed this writ petition for different category order. My lord, I consent with regard to the passing of order with regard to page number 29 of this honorable court.
29 has nothing to do with the present writ petition.
My lord,
You have asked for a copy of the license.
no, my lord, page 29 of my opposition. WP 25735 of 2022 passed by your lordship, my lord.
Yes, you were the petitioner therein.
My lord, I was the petitioner therein, but in this writ petition, my lord, your lordship has been pleased to direct the director to pass an order, my lord, with regard to the who has signed agreement with me in that proposition, my lord. My lord, may kindly take up in reply to a letter.
Why are you narrowing the scope of the order?
My lord, I am not narrowing. They have signed an agreement. My lord, this case is different.
AVL
Others were same. Others are on different footing.
AVL has signed an agreement.
My lord, that is my humble submission. My lord, they have signed an agreement that they are bound by it. They cannot deny it in the report by changing the nomenclature of the company. Signatories were same, my lord. My lord, signatories' name were in at page number. Page number 11 of my opposition, my lord. And writ petitioner, my lord, at the cost title. Just change the nomenclature from proprietorship company to private limited company. Rest are same. GST number is same. Everything is same. My lord, by changing the nomenclature, can they desist from their obligation?
What obligation are you referring to?
My lord, the obligations which are mentioned in the license agreement, that is the thing. They have to pay the royalty. These are the terms which were explicit in the agreement. If they are agreed by the agreement, then they have to go before the arbitrator as mentioned in the agreement.
Stated in the writ petition that an agreement was entered into between the parties.
No, my lord.
You have suppressed material facts.
No, my lord. Let him finish, thereafter I shall. Lordship, kindly come. Page 3 of my report.
Yes.
Before that, Lordship, kindly come cost title portion. Measures AVL Electric Vehicle Private Limited, a company registered under the Companies Act. Now, Lordship, kindly come page 3.
Yes.
Paragraph 1, third line. That one, measures AVL Electric Vehicle, a proprietorship firm subsequently incorporated as a company, namely measures AVL Electric Vehicle Private Limited, petitioner herein, with effect from such and such. That your petitioner states that the measures AVL Electric Vehicle is no more existing. Clearly stated. Not only that, Lordship, kindly come page 45 of my writ petition. I have not suppressed anything. Page 45 is the memorandum of article of association of AVL Electric Vehicle Private Limited. Now, Lordship, kindly come page 46, 47 onwards. This is the certificate issued by company, different authorities. Page 48 is the memorandum of association.
Everything I have annexed. Now Lordship kindly come his opposition.
What about the agreement?
I'm coming, my lord. Lordship kindly take up his affidavit in opposition. I am not saying this agreement is genuine. I'm not saying this agreement is false. I'm not saying on that because that will take up the main issue otherwise. I'm not saying on this anything. Lordship kindly come page 2, paragraph 4. Between the writ petitioner and respondent number 6. Respondent number 6, Mr. Sinha, and writ petitioner Lordship has seen is a company, not the proprietorship firm.
Paragraph 4.
Paragraph 4. That the instant short affidavit in opposition is filed bringing on record license agreement dated such and such by and between writ petitioner and respondent number 6. Writ petitioner I have showed your Lordship. Now Lordship kindly come page 10.
The
Agreement.
entities are the same. You have only
Entities
changed
are
the format.
Lordship, previously there was a proprietorship firm, subsequently and company has been framed. In the agreement,
Otherwise, everything else remains the same.
no, how can be? Because proprietorship firm that was in name of someone, and when it is turned into company, some more entities has to, one cannot form any company.
But that
Lordship
someone
kindly come
is here
page,
also.
Lordship kindly come. Lordship kindly come page 45 of my, 47 of my writ petition.
Yes.
Memorandum of Association,
47.
47.
Certificate of incorporation.
Lordship. Now Lordship kindly come page 10 of affidavit in opposition. Agreement for assignment of patent between Koniska Sinha and AVL electric vehicle. Entities are absolutely different. In this agreement, there is nothing saying that proprietor cannot subsequently raise his firm to a company, to a bigger company. It's a business. He cannot restrain, he can restrain so far as patent is concerned if it is at all genuine. I don't know. Lordship kindly see agreement for assignment of patent between Koniska Sinha and AVL Electric Vehicle Limited. Now next page, Lordship, third para, AVL Electric Vehicle represented by proprietor Mr. Such and such. Now preamble, a fuel cell system and efficient eco-friendly vehicle. So if we use fuel cell, then this patent applies. If we do not, he can be aggrieved. He can go to arbitration. So far as present petitioner is concerned, it's a different entity standing on the same footing with earlier companies, which your Lordship has passed out. Number one. Number two, a civil suit in before this honorable court is pending. Praying for, he has filed, praying for royalty. He can make that proprietor party there. He can go to arbitration, but that has got nothing to do with present writ petition. Scope of the present writ petition absolutely same with other companies. An order for registration of a vehicle. He is not remediless. He can make us party in that original side suit also. He can go to arbitrator if he feels aggrieved. Because of that thing, how can we be restrained from doing our business? And Lordship kindly come. Entities are absolutely different, my lord. Lordship kindly come page 145 of my writ petition. present petitioner's company is standing on the same footing, Lordship. 145. And I am not saying if this company has to pay royalty, that company will not pay royalty. Before that, he has to get some order from that original side suit or from arbitrator. He has to let him file and let him get such order. Lordship, kindly come page 145 once.
Yes.
This is the battery certificate. We are using
Lead cell battery.
absolutely. He is not remediless.
And
Let
the
him get some order regarding.
No, no, my lord, my learned friend is going to be different directions, my lord. Your lordship has asked, my lord, a very simple question to my learned friend, that whether the signatories were same or not, whether the company Amit AVL Electric Vehicle or AVL Electric Private Limited doing the same business or not. My lord, as per the Ministry of Corporate Affairs report published in the Ministry of Corporate Affairs website, AVL Electric Vehicle Private Limited, who is the writ petitioner herein, is having a director, Mr. Amit Makhija. Amit Makhija is the signatory of this company. In his own MOU, my lord, they have mentioned they are doing business of electric vehicle company, the same thing. My lord, the subject matter which my learned friend is trying to espouse, that it's a different thing, and going into the merits of the agreement is not the subject matter of this writ petition, my lord. In this writ petition, my lord, they have signed the agreement, and that agreement is binding upon them.
Agreement with earlier entity, not present entity, my lord.
No, my lord. My lord, may I take your lord? May I take your lordship to the portion? My lord, may I take?
Come to your agreement.
My lord, at page number, may I take your lordship to page number 15?
Yes.
Validity and enforceability.
Yes.
The rights of the patentee have been recognized by judgment order dated 21/4/2017, passed in WP number such and such, upheld by the Supreme Court of India, and order dated such and such, my lord. My lord, this
with regard to fuel cell battery.
no, my lord, this cannot be adjudicated, my lord, in this way, because they are in agreement. They are in agreement,
For
my
this
lord. My lord,
system is concerned.
For everything under.
I'm standing on
my
the
lord,
same.
they have signed the agreement, my lord. If the court
pertains to fuel cell batteries.
no, my lord. With regard to the subject
Right,
matter of the suit, with regard to the subject matter of the suit,
Page
my
11,
lord.
last para.
You
A
are
fuel cell
saying
system.
respect of fuel cell batteries only, not lead cell batteries.
My lord, I am not on the patent subject, my lord. My lord, this agreement is binding.
He's on
This
that
agreement
agreement.
is binding.
He's annexing that agreement.
My lord, this
Now he's
agreement
saying
is
I am not on that.
my lord, I have patent over the technology. First of all, the coordinate bench of this honorable court
Then
granted
other
injunction
orders
of the
passed by your lordship
technology,
and
not
all
on battery.
memos,
Not
all
on
should
battery.
go.
My learned friend is, first of all, my lord,
All
the
should go.
persons who are not having the agreement,
11 preamble says very clearly a fuel cell system and an efficient eco-friendly vehicle
I'm
mounted
grateful, my
with
lord.
fuel cell system.
my lord, I am
You cannot go
my
beyond
lord,
that.
my lord, I am acceding to that. But this is the my lord, my lord, my lord, I am acceding with that, my lord. I am not disputing that. My lord, this is the title of the patent, but the entire subject matter of the patent, what is the patent, is not mentioned herein. It is the title of the patent, the 254875. That patent,
is not
my
there.
lord,
How can
that
you say?
patent issue section 108 clearly says when there is a subsisting agreement, the read court cannot entertain.
With regard to fuel cell battery, sir, I repeat.
My lord, fuel cell
Welcome
battery
order,
is the subject matter. Subject matter, my lord,
File appeal.
that is a my lord, then I'm in this matter, I'm not giving consent, my lord.
So what?
No, let's-
I am objecting, my lord.
For learned counsels for the parties. The memos issued on 13 January 2022 and 13 July 2022 are assailed in the writ petition. Paragraph. Placing reliance in the affidavit submitted by the sixth respondent, Learned counsel for the learned counsel for the sixth respondent submits that this respondent entered into an agreement with AVL Electric Vehicles represented by proprietor Mr. Amit Makhija on 21st July 2019. Stop. Subsequently, the proprietorship firm has been converted into
AVL Electric Vehicle Private Limited, my lord.
Messrs. AVL Electric Vehicles Private Limited, comma, a company registered the Companies Act,
আমি এখন উঠতেই পারবো না আজকে 4:30-5টা
but the
4:30 পারবোই না
yes,
আজ ভাত
Mr. Deva.
saying something. Yes, Mr. Tripura, you want to make some submission?
no my lord, the lordship correctly said but between those particular
But the signatory
Mr. Amit Makhija, my lord.
of
ছবিটা এসে আওয়াজ নেই।
KMDA, I'm led by Mr. Dotto.
KMDA has to start today. Yes. I do not find Mr. Basu.
But I'm
And-
led by Mr. Basu, but nonetheless, my lord,
Right.
yes.
Yes, I'm
He's
for the representation. Yes,
Lord is.
Again, Kishore Dotto.
not ready.
No, my lord, he is coming. Mr. Dotto.
Why don't you
আরে
start?
তুই শুরু কর। পাসওয়ার্ড নিলে আবার চলে যাবে। শুরু করো ভাই। On the just here, on the last occasion, he started.
He did not start.
No, he did not start. You have to start fast.
Mr.
has not
Kishore Dotto, my lord, Mr. Kishore.
Yes, yes. He's not there, sir.
Sorry.
Mr. Talukdar is facing some predicament, I think.
Or would you pass it over? This is 3:30 matter. We are suffering like anything. This is continuing. What is going on?
Let them come and argue, otherwise wasting court's time is of no use. Let them come and if they are not present, may not pass it over kindly.
Yes. Well, let me then. Yes. So that the piecemeal is not done. That is why.
He has not started the other day. He was supposed to start today. Yes, you are rescued. Please rescue Mr. Talukdar.
একটা অ্যাডজমেন্ট চাইতে পারছো না আমার জন্য করে করে তো ড্র্যাগ করে চলছে
Milord, both Mr. Mukherjee and Mr. Sengupta, Milord, they have made, Milord, elaborate submissions, Milord, on the factual aspect. Milord, I don't think, Milord, your lordship is required to be troubled with that once more. Milord, first, kindly have a look to, Milord, the prayers to the writ petition. But at page 32 of the writ petition,
Yes.
where the first prayer is to issue a formal order of de-requisition. Then, Milord, your lordship may kindly turn the page. The second prayer is declaring the action subsequent to the order dated 29th of April 1997 passed by Honorable Justice Prabir Kumar Majumdar, as his lordship then was in CO. I'm sorry, Prabir Kumar Samanta, I'm so sorry. As his lordship then was in CO number so and so, in respect of the said land by the state respondents, including KMDA, are illegal, void ab initio, and not sustainable in law. Then we have the third prayer is to resign, withdraw the letter of 9th of December 2022, etc. Now, these are the fundamental prayers in the writ petition. Now, because of the second prayer, I think Mr. Sengupta has already addressed your lordship on that. That so far as the proceeding before Justice Samanto is concerned, Milord, the LA case before Justice Samanto was the subject matter of some other LA case, not the LA case, Milord, with which we are dealing. Now, Milord, only for just Milord, one or two documents that I'll please, for your lordship's consideration, please take Milord page 39 of the writ petition. Well, whatever may be the consequence of this order of Justice Samanto, Milord, we get Milord from the cost title to the writ petition over there. At page 39, your lordship finds in the matter of illegal notice in CA case number 27/1 by AC dash CMDA Act 2 of 1948 of 1984-85. Requisition for such and such. Before Justice Samanto, Milord, the LA case 2 of 1984-85 was under consideration, whereas, Milord, we are concerned about an LA case of 1986-87. Therefore, Milord, whatever may be the order of Justice Samanto, Milord, in my very humble submission, Milord, will not be applicable in respect of any other LA case. This would be, Milord, my first respectful submission before your lordship, Milord. But we are only concerned about, Milord, 3 plots, plot number 845, 846, and 847 part.
So Doctor, you'll take some time. So shall I release the other matters for the day?
Yes, sir.
Yes. Other matters, Shantanu. Other matters released for the day.
Other matter released for the day, except item 186.
Yes, continue.
Yes. Now, Milord, now please take, Milord, my affidavit in opposition. I have got a few fundamental pleadings through which, Milord, I need your lordship to be taken. My affidavit in opposition, that is KMDS, affirmed by Shubhajit Mondol.
Shubhajit Mondal, yes. Yes.
Only one thing I forgotten, Milord. The LA case before Justice Provish Samanto has also been stated by them in their pleading at paragraph 11 of the writ petition. Kindly only note that. Para 11 is at page 11 of the writ petition. Now, your lordship may kindly take, Milord, my affidavit in opposition. Paragraph 4A at page 2. This is my first point, that the petitioner is a post-vesting transferee. The said writ petition is misconceived, etc. The petitioner, admittedly being a post-vesting transferee, does not have any right to challenge the legality or validity of the acquisition proceeding in question on any ground whatsoever as allegedly sought to be made in the said petition, inasmuch as by the alleged purchase of the subject land in 2022, the petitioner did not acquire any right title interest in the land as the said land got vested in the state long before such alleged purchase by the petitioner, and that apart the said petition also suffers from inordinate delay, which alone disentitles the petitioner from getting equitable relief before this honorable court. But this is my first point. Then, my lord, facts, my lord, I would not trouble you much, except that please take page para 4C.
Yes.
Where, my lord, we have said that section 4(1)A notice has been issued. These have been already submitted by Mr. Shengupta, so I just only indicate. Then kindly take, my lord, paragraph 4G. In between para 4D, my lord, we have said that we had deposited the money. Then paragraph 4F, my lord, award was declared on 39/2024. Now here, my lord, what is relevant is your lordship gets, my lord, the LA case number at paragraph 4F. Before Justice Samanto, it was 27 of 1984-85. Here, my lord, we are concerned about 29 of 86-87. Then we have said, my lord, so many awardees, etc. But these have already been submitted by Mr. Shengupta. I don't trouble you much with this. Then we are at paragraph 4G. We have said that this LA case was not the subject matter before Justice Samanto. Then, my lord, 4H, again, my lord, we have said that notice under 4(1)A of Act 2 has been issued, and by that the land got vested. But only one factual aspect which, my lord, we feel that they had suppressed is, my lord, page 8 of my affidavit in opposition. Please take me about 6-7 lines from the top. The sentence starting with, it also appears from records.
Yes.
It also appears from records that Srimati Renu Devi Chaudhary and others, being the alleged vendors of the petitioner herein, had filed another writ petition number 20,128 of 2003 before this honorable court, inter alia, praying inter alia release of the plots of land from requisition allegedly made in connection with LA case number 27 of 1984-85, but had failed to obtain any so and so. Then, my lord, I go to, my lord, the document which was executed between the government and my client, which your lordship would find, my lord, at page 21 of my affidavit in opposition. But after the land was acquired, this is the sale deed, my lord, which has been executed in favor of my client on 1st of November 2004 between the governor and the Kolkata Metropolitan Development Authority. Now, please look at the schedule at page 23. The second, after paragraph 13, all that we...
Cannot transfer.
Yes, initially. For that, I'll make my submission whether he can dislodge me in respect of this document before a writ court. I'll make that submission. So far as, my lord, identification of the plots are concerned, please take, my lord, the schedule all that piece and parcel of land situated at Mauja, etc., containing so and so equivalent to 20.755 acres, comprising of dark numbers in full. First is 841, we are not concerned, then 845, 846 in full. The third line of the schedule. First, your lordship finds, but others dark in full skipping over 841, please take 845 and 846. And we are thereafter, after the rest of the RS DAG numbers, then RS number in part. But under that, the fifth one, 847 except northwest west corner. So 845, 846 in full and 847 in part. There is a report of the special land acquisition officer at page 26 of my affidavit in opposition.
Yes.
This was filed in the other writ petition which I have drawn your lordship's attention at page 8 of my opposition. So and so report on LA case number 29 for the project such and such in WP so and so. As per available office records, it is found on 2010-2022 as follows. Total number of RS plots in Moja so and so is 128. Date of award is 30th of September 2004. Total number of awardees 311. Out of 311, number of awardees receiving payment is 129. Awardees not receiving payment is 19. And awardees whose compensation payment was sent to the Land Acquisition Tribunal Court, Howrah, under section 30 is 163. Related RS plot of the writ petitioners 845, 846, 847 under Moja so and so was also involved. Name of the awardee of RS plot number 845 is Krishna Devi Agarwal. Total acquired plot is 0.33. Award declared amount is such and such. Sent to the LA court. Then kindly turn the page. Name of awardee in respect of RS plot number 846 and 847 is Sarveshwar Noskor, Sotto Noskor, Nitto Noskor, both son of so and so. Acquired area is 0.04 and 0.09 acres respectively. Then declared amount and whatever has been done. So this is something on record brought forth by the Special Land Acquisition Collector. Now this Krishna Devi, my lord, she is the vendor of the petitioners. Now, my lord, much has been said, my lord, on the other factual aspect. My lord, I don't think, my lord, these are needed to be gone into. Only, my lord, in respect of that pleading, please take, my lord, page 5 of my affidavit in opposition. Para 4F, apropos, my lord, the last document I placed before my lord. Para 4F at page 5. It appears from various communications of the state authorities, one of which is memo number so and so, issued by the additional district magistrate and district land and land reforms officer, Howrah, to the additional secretary to the government of West Bengal Department of Land and Land Reforms, that the award was declared on 39/2004, and the total number of plots involved in 128 numbers is 128 numbers, and the number of awardees are 311 numbers in connection with LA case number 29. Out of 311 awardees, 129 awardees have already received the compensation amount, and 19 numbers awardees did not receive. And in respect of 163 number of awardees, the compensation amount was sent to the LA Tribunal, Howrah, which includes the awardees of the subject land, that is RS plot number so and so, namely Krishna Devi and others, from whom the Yes, from whom the vendors of the petitioner, namely Renu Devi, Chaudhary, and had allegedly purchased the land in question. Number, these are the basic facts. Number on the
LA case number.
yes, LA case number and what is the right of a post-vesting transfer, and what happens to the sale or the transfer that has taken place after the property has been acquired. But there is one judgment of the Honorable Supreme Court which has collated all the points in regard to a post-vesting transferee or a post-vesting transfer, and the Supreme Court has held that there is no scope of any interference thereafter. But this is reported in 1996, volume 11, Supreme Court cases, page 698. Now, my lord, please take paragraph 3 and 4 of this judgment. Sri P.P. Rao, learned senior counsel for the petitioner, contains that the petitioner had no knowledge of the acquisition proceeding. As soon as it came to know of the acquisition, it had challenged the validity of the acquisition proceeding, and therefore it furnishes cause of action for the petitioner. In my very humble submission here, there is no direct challenge to the acquisition proceeding. That's why, I have taken your lordship through the prayers. What they want is they want back the land to them, to be handed over to them. He further contends that the writ petition could not be dismissed on the ground of laches because, but was required to be considered on merits. We find no force in the contention. Any encumbrance, from here, I lay emphasis, any encumbrance created by the erstwhile owner of the land after publication of the notification under section 4.1 does not bind the state if the possession of the land is already taken over after the award was passed. But this, of course, is a case under Act 1. The land stood vested in the state, free from all encumbrances under section 16. In Gurmukh Singh, this court had held that a subsequent purchaser is not entitled to challenge the legality of acquisition proceeding on the ground of lack of publication of notification. In Yadu Nandan Garg and Snehoprabha, this court had held that the alienations made by the erstwhile owner of the land after publication of notification under section 4.1 do not bind either the state government or the beneficiary for whose benefit the land was acquired. The purchaser does not acquire any valid title. Even the color of title claimed by the purchaser was void. The beneficiary is entitled to have absolute possession free from encumbrances. In UP Jal Nigam versus Kalra Properties, this court had further held that the purchaser of the property after the notification under section 4.1 was published is devoid of right to challenge the validity of the notification or irregularity in taking possession of the land before publication of declaration under section 6. As regards laches in approaching the court, this court has been consistently taking the view, starting from State of MP versus Bhailal Bhai, wherein a constitution bench had held that it is not either desirable or expedient to lay down a rule of universal application, but the unreasonable delay denies to the petitioner the discretionary extraordinary remedy of mandamus, certiorari, or any other relief. The same view was reiterated in Caten of decisions, but then the decisions are collated, wherein this court had held that the High Court was not justified in interfering with the acquisition proceedings. This court, in the latest judgment in Municipal Corporation of Greater Bombay, reviewed the entire case law and held that the person who approaches the court belatedly will be told that latches close the gates of the court for him to question the legality of the notification under Section 4, declaration under Section 6, and the award made by the collector under Section 11. Therefore, this appears to be one of the shortest judgment on all point in one paragraph. Therefore, what is the effect? First is, rightly or wrongly, the previous owners, they had shown a challenge in 2003, but later on did not proceed, whatever may be the reason. We may not be considered about that. But later on, they have sold the land to my learned friend's client. Now, first is on the point of whether at all they can throw a challenge or not. It says that anything done subsequently do not bind the state or the authority to which the land has settled law. The second part is, so far as the transaction that has taken place between the post-vesting transferor and the transferee, that is void. There, I lay emphasis. If the transaction itself is void and if no right is accrued or acquired, not accrued, acquired by virtue of that sale transaction or sale deed, in my very respectful submission, a post-vesting transferee, can under no situation throw a challenge, to any, even acquisition proceeding. We are here, your lordship has found, there is no challenge to the acquisition proceeding also. And the third aspect of the matter is the latches. Now, the date of the award, your lordship has got, and the date of the proceeding is 2022. The year of the proceeding is 2022. Now, this huge delay, is again a ground not to, entertain the writ petition by this honorable court. This, your lordship would again get me at paragraph 4 of this judgment. In this case, admittedly, the petitioner has purchased the property covered by the notification under Section 4(1) after it was published, and therefore its title is a void title. It has no right to challenge the acquisition proceeding, much less the award. The division bench of the High Court has exhaustively reviewed the case law to negate the claim of the petitioner. We do not find any illegality in the judgment of the High Court warranting interference. Yes, special petition dismissed. Therefore, this is what has been laid down. So many submissions have been made before your lordship that after 1A notice, if the award is not passed within a prescribed period, then what happens? The proceeding lapses. Now, the point is, whether, this argument, whatever may be the merit of this argument, whether this can be canvassed before this honorable court, by a post-vesting transferee. My very respectful submission is, that by virtue of this star iron, this challenge or this contention cannot be put forth before a writ court because your sale deed is void, or you have not acquired any right title interest after that. But again, those fundamental first principles that before a writ court, you don't come to establish a right. You come here to enforce an established right, legal right. Now, if the sale deed is void, then in my very respectful submission, no right subsists in the present petitioners, for the purpose of, enforcement thereof before a writ court. On the delay aspect, please once again note down the date, The award is on 30th of September 2004. And bereft of the challenge to the entire proceeding, the writ petition is in 2022. Yes, but the other judgment is, why I gave the dates, please have a look to me at another judgment. This is Dhobi Sethi, 1995, volume 5, Supreme Court cases, page 583. But here, the acquisition proceedings was challenged after a lapse of 7 years. Paragraph 2, a notification under section 4.1 was published on 16/7/1970 in respect of so-and-so plots. Then along with the notification, the appellant invoked the urgency clause under 17.4, dispensing with the requirement of inquiry under 5A of the Act. The declaration under section 6 was published in 72. Notice under section 9.10 published in December 75. Possession taken in 16/12/1976. Sometime in 1977, OJC number so-and-so of 1977 was filed, questioning the validity of the exercise of power under section 17.4, dispensing with the inquiry under section 5A. Similarly, some of the owners filed OJC so-and-so of 1978, claiming interest for part of the land pursuant to a sale made after the notification, namely in November 1973. Both the writ petitions were allowed by the High Court on the ground that there was no justification to dispense with the inquiry under section 5A, and public purpose would have been served by allowing the claimant to submit their objection. But this was the ground on which the High Court had allowed. As regards the second writ petition, namely so-and-so, the petitioner therein cannot raise this objection because he is a subsequent purchaser, and that the High Court was unjustified in allowing the writ petition. As regards OJC 43 of 77, in view of the fact that the notification was issued as early as on 1970, the writ petition having been filed after 7 years, the High Court ought to have dismissed the writ petition on the ground of laches. We therefore hold that the High Court has not properly exercised jurisdiction under Article 226. Reported decision now. The Municipal Corporation of Greater Bombay has been considered in Star Iron. But please have a look to that, and then I am over. This is 1996, volume 11, Supreme Court cases, page 501. Yeah, 96/11/501. But please take 4 paragraphs, paragraphs 25 to 29. Where para 25 speaks of Dhobi Sethi Miller, the last judgment I have handed up. Then para 26 speaks of State of Maharashtra versus Digambar. 27 Ramjas Foundation. 28 Ramchand. These are all considered. And finally, please take para 29. It is thus well settled law that when there is inordinate delay in filing writ petition and when all steps taken in the acquisition proceedings have become final, the court should be loath to quash the notifications. The High Court has no doubt discretionary power under Article 226 of the Constitution to quash the notification under Section 4.1 and the declaration under Section 6. But it should be exercised taking all relevant factors into pragmatic consideration. When the award was passed and possession was taken, the court should not have exercised its powers to quash the award, which is a material factor to be taken into consideration before exercising the power under Article 226. The fact that no third-party rights were created in the case is hardly a ground for interference. The division bench of the High Court was not right in interfering with the discretion exercised by the learned single judge dismissing the writ petition. Therefore, after everything is done, possession taken, award passed, people have taken money, those who did not accept the money, whatever is required under the rules, that has been done, money is deposited at the appropriate place. Therefore, these kinds of cases, in my very respectful submission, do not warrant any interference by this court. And once again, at the risk of repetition, please have a look to the prayers.
এটা দিয়েছে কিশোর আমাকে
Now, this issuance of the formal order, deed acquisition, my lord, in my very humble submission, my lord, is not permitted, my lord, at the instance of parties who all along sat tight. The vendor had challenged it. Now, my lord, they cannot come and challenge before this. But these are my suspicions. My lord, but only kindly permit me to supplement one thing. Well, in the document which is annexed to my affidavit in opposition, at page 22, the second page is missing. No, sorry. What yes. But the second page is missing, if I may,
Yes, second page is missing.
but kindly permit me, Lord, my clerk to stitch this, my lord. Please treat this, my lord, as page 22A. সব কিছু চাই কেন তো
সব কেড়ে নিচ্ছে তো
আচ্ছা দুটো নেই এখানে হবে একটা আছে না তারপরে কতটা তিন আছে
এই পাতালি তো অন্য পাতা থেকে ঢুকি না অন্য একটা এগ্রিমেন্ট থেকে ঢুকি
তাও হতে পারে এম দিয়েছি
এমডিএস সব পাই
হ্যাঁ
That's all your submission.
I'm grateful.
Yes. Respondent number 11.
Whenever your lordship pleases, my lord,
Not today.
Mr. Basu is not there. And my lord, insofar as the vesting and the acquisition is concerned, our scope is very limited because we are the private respondents. But whatever, my lord, transpires from the documents, we will restrict our submissions to that.
They can adopt the submissions of Mr. Dodda and
Perhaps
Mr.
not, my lord,
Sengupta.
because factually,
Also has to be clear.
my lord, there are a few points which perhaps we might be required to indicate.
Mr. Korvena. May I take your lordship's leave?
Well, lord, I've just received a request from Mr. Basu, my lord, if it could be fixed next Wednesday at 3:30.
Next Wednesday is 30th. Maybe 30th at 3:30 কিছু আছে কিনা দেখুন 30th August at 3:30. I keep fixing matters at 3:30, so let me just find it.
Because, my lord, we won't be taking, I don't think, more than half an hour maximum, my lord.
And I did not want to open my mouth because there may be difference of
For learned counsel for the no money.
no money.
Learned counsel for the KMD.
আমি হয়তো অনেক কিছু ওপেন করব
There's a 3:30 on next Wednesday. I cannot.
Then Tuesday.
It has to be Mondays and Wednesdays.
So coming Monday.
Monday, my lord, I'm told, my lord, Mr. Basu is in some difficulty, my lord.
4th September. Council for the KMU paragraph. Let the matter appear under the same heading for further consideration on 4th September.
Monday?
4th September, sir.
Grateful. Number of Mr. Sengupta was supposed to file written short written notes.
দরকার নেই এখন দরকার নেই
Binding of that judge.
Against final binding.
আসবে না
Sir,
Mr. Mukherjee had requested a short written note from your side. Court will not make a comment.
Yes.
He'll come back with it the next day.
grateful
Grateful.
4th September, 3:30.
September. Yes, 3:30. Mark at 3:30.
Okay, 3:30.
Otherwise, not 3:30.
Mark as 3:30.
Yes.
চিন্তা করে রেখেছি
174. Yes.
Oh, other matter so.
That day.